No.
Defense? No. All right, thank you. All right, Mr. Rudolph, thank you for being with us today. I don't know if Bay City is snowy today, but I can assure you West Michigan is. So you're probably you had a safer commute from your office to whatever room you're in than you would have had you had to drive over today. So let's proceed with the testimony. Thank you, Ms. Omenroyd.
May I approach to him?
Thank you. Yes. Thank you, ma'am.
Good morning, Mr. Rudolph.
Good morning.
You are an employee of the state of Michigan's Department of Environmental, Great Lakes and Energy, also known as Eagles, in the Water Resources Division, correct?
Yes.
You have been employed by Michigan Eagles since 2000, correct?
Yes.
You were first employed as an environmental quality analyst, correct?
Yes.
And then you became the acting district supervisor in 2009.
Yes.
And then in 2010, you were promoted to full-time district supervisor for the Water Resources Division unit in Bay City. Is that correct?
Yes.
And you are still the district supervisor for the Water Resources Division unit in Bay City, correct?
Yes.
You are a biologist by training and education, correct?
Yes.
You received a bachelor's and master's degree in biology from Central Michigan University, correct?
Yes.
When you were environmental quality analyst, your duties primarily involved reviewing permit applications as well as investigating complaints and taking action on those complaints, correct?
Yes.
When you review an application, your decisions are guided by statutory requirements and administrative rules, correct?
Yes.
The Water Resources Division is a regulatory agency, correct?
We are a division of Eagle, which is a regulatory agency. Yes, ma'am.
In your role as the district supervisor in the Water Resources Division, you are responsible for overseeing staff as they administer statutes, correct?
That's correct.
You also review applications and conduct compliance inspections, correct?
Yes.
And you were responsible for those duties between 2018 to 2020, correct?
Yes.
And you continue to be responsible for those duties, correct?
Yes, that's not my primary role as supervisor, but yes, I am involved in those duties.
Issuing or denying permits for the drawdown or refill of water levels under Part 301 falls within your responsibilities, true?
Falls within our responsibilities, yes.
When you say our, what are you referring to?
Water Resource Division.
And you execute those responsibilities, correct?
Yes, at times. I guess it's important to distinguish. As a supervisor, I currently don't have any assigned counties in which I actually are assigned permits to review or compliance. That's my staff does that. But that's not to say I don't get involved and at times do still issue some permits.
And did that responsibility change since your deposition in earlier in 2025?
Actually, I was responsible for a specific county earlier in 2025. I no longer am. That's covered by one of my staff.
And between 2018 to 2020, were you responsible for issuing permits?
Yes.
And you pardon?
I didn't say anything, ma'am.
The geographic area for which the Bay City office is responsible includes Midland and Gladwin counties, correct?
Yes.
And that was true in 2018 to 2020.
Yes.
The Edenville Dam was located in your geographic area of responsibility, correct?
Yes.
And during your tenure with the state of Michigan, you were aware of the Edenville Dam, correct?
Yes.
For most of your tenure with Eagle, you would have been aware that Edenville Dam was producing hydroelectric power and was subject to the jurisdiction of the Federal Energy Regulatory Commission, or FERC, correct?
I was aware that it was a hydro dam. I was aware that it was regulated by FERC. That's about it.
You were also aware that in 2018, FERC revoked the Boyce Hydro's license to produce hydroelectric power, correct?
Yes,
And in 2016, prior to FERC revoking the license, the state of Michigan brought a lawsuit against Boyce Hydro for a Part 301 violation, correct?
I'm sorry. Could you restate that? I apologize. These lights occasionally will try to turn off. My apologies.
Okay. In 2016, prior to FERC revoking the license, the state of Michigan brought a lawsuit against Boyce Hydro for a Part 301 violation, correct?
Yes,
And you were involved in that litigation, correct?
yes.
What again, please?
2016.
Thank you.
That litigation involved work being performed allegedly without permits, correct?
Yes,
And it also involved some allegations of impact on the wetlands, correct?
yes,
You were aware when FERC reverted the license in revoked the license in 2018, the Edenville Dam came under the state's jurisdiction, correct?
yes.
You are familiar with Part 315 of NAREPA, correct?
I know that obviously I know it exists. It's something that's administered by our department. I'm not sure what you mean by familiar. I don't administer Part 315, so I don't know its requirements and rules.
But you are aware that Part 315 involves dam safety.
Yes,
And Eagle's Dam Safety Unit is responsible for administering Part 315, correct?
yes,
When you review a permit application that involves a dam subject to Part 315, you consult with the Dam Safety Unit, correct?
yes,
And as part of this consultation, you would ask the Dam Safety Unit to review the requirements under Part 315 and to provide any comments on the permit application, correct?
yes,
And you would also consult with the Dam Safety Unit to ensure that any areas that fall within the responsibility of the Dam Safety Unit are being acted upon in compliance with Part 315, correct?
yes,
So the Water Resources Division's Bay Cities office's responsibilities for permitting under Part 315 intersect with the Dam Safety Unit's responsibilities under Part 315, if the dam is subject to Part 315, correct?
My office, the Bay City District Office, does not administer Part 315. So we're not responsible for that review, nor do we administer 315. For projects that include 315 dams, we get comment and review from Dam Safety Unit.
Okay. You would not deny a permit to draw down water levels at a dam subject to Part 315 without consulting with the Dam Safety Unit, correct?
No, I believe we would consult with Dam Safety.
And you wouldn't raise the water levels or refill a reservoir at a dam subject to Part 315 without consulting with the Dam Safety Unit, correct?
Yes, I believe that's correct.
And isn't it true that your primary concern when you interact with different units is whether or not the issues under review are conducted in compliance with statutory requirements?
Yes,
And you are aware that the Edenville Dam was subject to Part 315, correct?
Once Burke revoked the license, yes.
And Luke Trumbull was your primary contact for dam safety between I thought I heard something. Okay, Luke Trumbull was your primary contact for dam safety between 2018 and 2020, correct?
I believe that's correct. Jim Pulowski was in his role prior to that, and he had retired. I'm not sure exactly the dates on that.
But after Jim Pulaski retired, Mr. Trumbull became your primary contact, correct?
Yes,
In 2018, there was a drawdown of Wixom Lake, correct?
yes,
And in the fall of 2018, you and your staff started to flag concerns with the mussel population as a result of the Wixom Lake drawdown, correct?
we did note that there were impacts to the resources, including stranded mussels. Yes. Excuse me.
And during the fall of 2018, you and your staff were involved in conducting surveys of the mussel population, correct?
I did not conduct the surveys, but I had staff that participated with the DNR on survey work.
And isn't it true that you advocated within your department to pursue damages for what you believed were natural resource damage to the mussel populations in Wixom Lake due to the drawdowns, correct?
Well, we are required to account for natural resource damages for violations of law.
I asked you if you advocated to pursue damages for what you believed were natural resource damage to the mussel populations in Wixom Lake due to the drawdowns.
I'm sure I did, yes.
And you wanted Boyce Hydro to be pursued for fines as well as damages, correct?
I wanted statutory relief allowed under Part 301 for impacts. Boyce Hydro was responsible for those violations.
So you wanted them to be pursued for fines and damages, correct?
Well, I want to make a distinction. This isn't a I wanted issue. I represent the agency, and part of our statutory responsibility is to ensure that where appropriate, relief is sought, in this case for damages to the natural resources of Wixom Lake resulting from the drawdown without a permit.
Mr. Rudolph, let's have an understanding. When I say you, I am speaking to you as the district supervisor of the Bay City office of Eagle. I am speaking to you in your capacity as representative of the state of Michigan. Can you agree with that?
Yes, ma'am. Thank you. I just wanted to be clear.
I want to show you Exhibit 56. Plaintiff's Exhibit 56. Okay. Let's look at page 2 of the exhibit, your October 22, 2018 email. Can you see that on the screen?
Yes, ma'am.
And in that email, you indicated that one important issue that does require follow-up is that the SBDO staff observed stranded and or dead mussels in Wixom Lake last week while doing site inspections. How we and or the DNR follow up on this needs to be addressed, especially in light of the current litigation against Boyce Hydro. So you were concerned with litigation at that point in time, correct?
We were in litigation at that time, yes.
Okay. You were also, at that point in time, the Eagle was concerned with how they could have the water levels raised so that to protect the mussels. Isn't that correct?
No, not to necessarily protect the mussels. The drawdown was done in violation of Part 301.
The-
So it's the impacts to the natural resources were much more than just mussel populations. It would have included reptiles, amphibians, and fish species as well.
Whether it was mussels or other natural resources, Eagle was discussing options how to obtain a lake level order. Isn't that true?
There were discussions on how to obtain a lake level order, yes.
And in fact, Kim Fish, the director for Eagle, discussed with whether then MDEQ, which is Eagle, and DNR, whether a director's order could be issued regarding the lake level, correct?
I believe that's what this email states, yes.
And you recollect that, correct?
Yes.
Because, and the reason they wanted to obtain a lake level, or the state wanted to obtain a lake level order was to protect the mussels and the other ecological issues, correct?
No, I don't think that's correct. We were being asked what avenues were available and if Eagle had the authority to require the lake to be refilled. And Ms. Fish was pointing out that under 307, she
That's
didn't
not my,
feel that we did.
can we stick with answering my questions?
I apologize. I thought I was. Can you restate your question, please?
On this email chain involving mussel issues, the Kim Fish was considering whether or not Eagle could move on its own to have the lake level raised, correct?
Yes. Can you put the portion of Ms. Fish's email back on the screen, please?
We will do that. Go ahead.
Thank you. Okay, thank you.
So it was being considered whether Eagle could move to have the lake level set, correct?
We were asked, I believe DNR asked if we had the ability or authority to do so.
The state of Michigan was considering whether or not that it can move to set the lake levels, correct?
I suppose that's correct, yes.
Okay, let's look at Exhibit 59. Let's look at page 3, the October 26, 2018 email from Krieger to you. Mr. Krieger advised you that we are trying to decide on any potential action as a resource damage review for this extended drawdown. Do you see that?
Yes, yes, I do see that.
Okay. Let's go to your October 30 email.
Hold on, please.
I'm
I'd like to
sorry.
read it. Thank you.
Let's go to the October.
Hold on,
Oh,
please.
sorry. Excuse me.
Okay.
Let's go to page 1. This document, which is a continuation of this chain that we just spoke of. And Mr. Dickinson, can you highlight the October 30, 2018, 119 email from Mr. Rudolph to Miss Mystic and Mr. Krieger? Can you see that?
Nothing is highlighted, ma'am.
Okay. If you, within that email, you indicate they are at this point in violation of Part 301 for the drawdown, and I believe we, AG office, is rolling this complaint into the current litigation we have ongoing. This is one of the reasons I think we will be asked to assess the NR damages due to the drawdown.
Yes, I see that.
So at that point in time, you were working and contemplating litigation involving the drawdown of Wixom Lake.
This is referring to the existing litigation at the time and whether or not the violation of the drawdown would be included in that.
Whether it's included, you want to have allegations related to the mussel population, correct?
I'm sorry, can you restate that?
You want to bring action, whether it's included in a prior action or a new action against Boyce Hydro for the mussel population, correct?
That is relief under statute is what we would seek, yes.
Let's look at Exhibit 68. Can you read the part where it says, let me echo Eric, thanks for pulling this effort together so quickly. Can you see that part of that email?
I can. It's awfully small, but yeah, I can read it.
Okay. And in it, you indicate it will be a valuable part of the litigation going forward. Correct?
Yes. Thank you for highlighting that. Yes, it does say that.
Let's look at Exhibit 134. That is an email from you to Dave Pingle, Nathan Gamble, Helena Nelson of Eagle, and Jessica Mistak, dated December 11, 2019. Do you recognize this email?
Yes.
And in it, you indicate that Boyce is in violation of Part 301 and likely the Part 307 order issued by Judge Karras as well, correct?
One moment, please.
Yeah, I'd like a minute to read it. It's single space, entire page, so give me a moment, please. And it appears that there are no attachments to Exhibit 134, yet the email references them.
We did not attach. We don't have attachments.
Thank you. Right, thank you. You may proceed.
In the second paragraph of that email, you indicated that I observed stranded dead mussels at the Dundas Road, Dale Road, and Billing Township sites, correct?
Yes.
And so you personally inspected for the mussels, correct?
That was not a mussel survey. What I was looking for, what I and others were looking for, was the amount of drawdown that was being undertaken. We observed, and yes, I observed dead and stranded mussels at that time. But that
And
wasn't the purpose of why we were there.
you weren't. In any event, in the third paragraph, you indicate it is my intention to draft a violation notice for the drawdown activity and advise they cease actively conducting a drawdown and come into compliance with Part 301 and the Part 307 order. Do you see that?
Yes,
And did you do that?
yes.
And in fact, you did issue an enforcement notice, correct?
I believe it was an enforcement notice, yes.
Yeah.
They're two different mechanisms of the same sort of result.
Let's turn to Exhibit 135, page 2. Can you see that document?
Yes,
And you advise, it's addressed to Lee Mueller. It's dated December 12, 2019.
ma'am, all I can see is this address. Okay, now I see the address, yes.
Okay. And at page 1 of this letter, you advise Mr. Mueller, if you do not immediately cease the drawdown and return Wixom Lake to the level authorized under the Part 307 order, ECO may take escalated enforcement action against Boyce Hydro and others who are collaborating with Boyce on the drawdown. That could include referral of the case to the Department of Natural Resources, Environmental Investigations Section, and the Department of Attorney General, correct?
Can you complete that all the way up? It's not all the way shown. That fourth paragraph, please.
Can you see it now?
Well, I don't think I can see the bottom sentence, but I can read the bulk of it. Oops. Okay, there we go. Thank you. Yes, I see it.
You also, in this letter, at the third paragraph, advise Mr. Mueller Eagle would like to provide you with with an opportunity to comply with the legal requirements of Part 301, Part 307, and Part 303 by immediately seizing active drawdown of Wixom Lake and coming into compliance with the Part 307 Lake Order. That is the best way you could mitigate the damage the drawdown has caused the state's natural resources and prevent the additional damage you will cause if you draw Wixom Lake down to the level you applied for in your permit application. Should you wish to discuss compliance requirements, please contact me as soon as possible. Correct?
Yes, that's what it says.
Okay. And there's no mention of anything to do with dam safety in that enforcement notice, correct?
No, this was relative to the drawdown. That's regulated under Part 301.
It was relative to the drawdown and concern with natural resources, correct?
Part 301 is primarily concerned with natural resource damages, yes.
Okay. Okay. Okay, I'm going to show you plaintiff's exhibit 154. which is a permit issued to Boyce on April 9, 2020, and that expires on December 31, 2020. Have I correctly described this document?
Yes.
Let's go to page 4. That's your signature on this permit, correct?
Yes, it is.
And by issuing this permit, you approve the raising of the water level of Wixom Lake to the summer pool elevation of 671.2 feet, correct?
It was to the summer elevation. I don't think that number is correct, but yes, it was to the summer elevation as stated in the Part 307 order.
And you consulted with dam safety before issuing the permit, correct?
Yes.
And Mr. Trumbull, nor anyone in dam safety ever suggested to you that raising the water levels would jeopardize the safe operation of the dam. Is that correct?
That is correct.
Nobody from dam safety suggested the heightened water levels would be a danger to the residents and businesses downstream of the dam, correct?
That is correct. No one ever said that.
When you signed the permit authorizing the water level to be raised in April 2020, you were not aware that in January 2020, Mr. Trumbull determined that the Edenville Dam could not meet the state's mandatory requirements for 1/2 PMF, correct?
I know those were ongoing discussions, had been an issue with the dam.
Did you know that the Edenville Dam could not meet the state's mandatory requirement for 1/2 PMF?
I believe so, yes.
Mr. Rudolph, if the dam safety people had genuine concerns about issuing the permit to raise the Wixom Lake water level, it would have been your expectation that they would have told you that, correct?
Yes.
And it's correct that they never told you that they had genuine concerns about issuing the permit.
That is correct. Nobody stated there was any concerns about issuing the permit.
And no one told you that the dam's inability to pass the 1/2 PMF test under Part 315 was a genuine concern, correct?
It concerned relative to what, ma'am?
Concern for whether the dam was safe.
At no point did anybody tell me that raising the water level in Wixom Lake was unsafe.
And if someone had told you that, the permit would not have been issued, correct?
If we knew the dam it would be unsafe to raise the level to the summer level, we would not have issued that permit.
And if the facts that it could not pass 1/2 PMF was unsafe, you would not have issued the permit, correct?
I don't know that that's the case. I don't believe anybody said that was the case.
I'm not asking you if someone said it, sir. I'm asking you if the fact that the dam could not pass the 1/2 PMF meant the dam was unsafe, you would not have issued the permit, correct?
I don't know that that's an accurate statement, ma'am. I'm not sure I can answer that because I don't know if the 1/2 PMF requirement by default means the dam is somehow unsafe. I was never told that.
If you assume that not passing the 1/2 PMF was unsafe, you would not have issued the permit, correct?
I can't make that assumption. That's an engineering
Hold on a
decision.
second. Hold on a sec, please. What's the objection?
Asked and answered.
The witness was called under the sort of hostile witness, so it's more akin to cross. So that basis of the objection, I'm going to respectfully overrule. Yeah, I think the witness already answered. Could you just restate your answer? I don't presume to speak for anyone other than myself, and sometimes I don't even presume to speak for myself. But if you could indicate what you just said again, Mr. Rudolph.
Yes, Your Honor. I don't think I can properly answer that because it's a question for engineering. It's an engineering question, and I'm a biologist, not an engineer. So I wouldn't want to assume that I could make those determinations.
All right. Do you understand the answer, Ms. Holman-Road?
Yes,
Okay, you may continue.
I want to refer you to do you have a copy of your deposition?
I do not.
Do we have this deposition available? Oh, great. Let's go to page 60.
Do I have that?
Oh, I'm sorry. I have to bring it up to you.
No, you don't have to. I mean, I
I do
can
have-
watch. He's got to watch it on the screen. I'll watch it on the screen.
I have one copy, so may I
It's
press?
all, I'm sorry, it's all the appendix exhibit 1.
Okay, thanks. Sure, thanks. All right, Mr. Rudolph, everybody has it but you.
I can see it, Your Honor.
What page?
The page 60,
Thank you.
line 25.
Okay, please proceed. I'm with you.
At line 25 of page 60, you were asked by me at your deposition of March 10, 2025, if it was ever brought to your attention that the dam, then continuing on to page 61, lines 1 through 7. Is that up? Okay. Could not pass the 1/2 PMF statutory requirement for this dam, would you have raised this issue with anyone? Answer, we would have discussed it to be sure. If it was a genuine concern, if they were really concerned, it's something that should have prevented the permit from being issued. That was your testimony, correct?
Yes.
And if Mr. Trumbull testified in these proceedings that the fact that the dam could not pass the 1/2 PMF was a genuine concern, the permit should not have been issued, correct?
Can you restate that? I'm not sure I followed that question.
If you assume
Okay.
that
Sorry.
Mr. Trumbull testified in these proceedings that the fact that the dam could not pass the 1/2 PMF was a genuine concern, that the permit should not have been issued, correct?
I don't think I can assume what Mr. Trumbull may have testified to.
I'm allowed to ask
Understood.
you hypothetically to assume that.
If dam safety unit, that primarily being Luke Trumbull, had said that the dam was unsafe or would fail when refilled due to the 1/2 PMF, then the department would know that the dam should not be refilled. I would assume we would not issue a permit. But I don't, hypothetically, I never remember that occurring.
My question required a yes or no answer. Can you answer my question?
I apologize. I'm just trying to give you the best answer I can to a hypothetical. I don't believe we would, based on your question.
You don't believe you would have issued the permit, correct?
I don't believe Eagle would have issued a permit based on your hypothetical question. Yes.
Okay, thank you very much.
All right, is that it?
That's it.
That's all right. Thank you.
Out of your way.
Mr. Thompson, you may examine. If you can introduce yourself to the witness. Thank you.
Good morning, Mr. Rudolph. My name is Jason Thompson. I'm one of the plaintiff lawyers.
Good morning.
How are you?
I'm well, thank you.
Good. I just want to follow up on the last discussion. If I understood the testimony correct, if there was a genuine concern from the dam safety unit about raising the water, your normal practice and expectation was that they would tell you about that concern, correct?
Yes,
And you would rely upon their input on those genuine concerns, correct?
yes,
And that's true in terms of whether you would grant or deny a water level permit, correct?
yes, that was the question at hand. Yeah,
Okay. And that would cover the Edenville Dam also, correct?
that's the dam we were discussing, or that's the dam in discussion, yes.
And that was your process in 2018, 2019, and 2020, correct?
To consult with dam safety unit on specific issues that dealt with dams, yes.
Yes, sir. And that was true when this permit was pending in 2020, correct?
I'm sorry, are you asking, did we consult with dam safety on this permit?
No, sir. Your process that we've discussed, that you would request information from them on a 315 dam.
Yes, we would request review and comment.
And that was the process when this permit for the April 9th water level increase was pending, correct?
Yes,
Okay. And if Mr. Trumbull had genuine concerns over the safety of raising the water, you would have expected him to let you know that, correct?
yes,
And if he had genuine concerns, the permit should not have been issued, correct?
yes, I believe that's correct.
And if Mr. Trumbull testified the fact that the dam did not pass 1/2 PMF was a genuine concern, you would have expected him to tell you that, right?
Uh, Is this another hypothetical question, sir?
No?
Okay, could you restate? I apologize.
Yeah. If Mr. Trumbull testified that the fact that the dam did not pass the 1/2 PMF was a genuine concern to him, then the permit should not have issued under your process, correct?
A concern regarding what specifically?
I said the fact that it could not pass the 1/2 PMF. That was the genuine concern to Mr. Trumbull. If that's what his testimony is, then under the process you've described and you consider genuine concerns, is it fair to say that that permit on April 9th should not have been issued?
I don't know, because I don't know how to answer that. I don't want to be evasive. But if is it a concern whether they meet statutory requirements because it had operated that way for quite some time? Or was it a concern that it would cause the dam to be unsafe in some way?
Well, you raise an interesting discussion. So you would have expected Mr. Trumbull to have that type of a discussion with you when you requested his input, correct?
Yeah, I think that's correct.
And that type of discussion never happened, did it?
There was no discussion that it was unsafe.
There was no discussion about it failing to meet the 1/2 PMF either, was there?
Well, there were a lot of discussions involving the 1/2 PMF, but there were primarily between engineers involved, Spicer for Four Lakes and dam safety. I was looped in on a lot of those conversations, but as I said previously, I'm not an engineer, so I didn't get involved in those.
Right, you relied upon an engineer like Mr. Luke Trumbull to help you with this decision, correct?
Yes, that's true.
And my question to you is, Mr. Trumbull never advised you in 2020 that he had calculated the 1/2 PMF test and that the Edenville Dam failed it, did he?
I don't recall if he ever specifically said that or not.
Right. And your testimony was that if there was a genuine concern about the safety of the Edenville Dam at the increased water levels, that permit should not have been issued. We've already established that, correct?
Yes,
All right. And that was the process that you were following in 2020, correct?
yes,
And if Mr. Trumbull testified that he had a genuine concern, you'd agree the permit should not have issued, right?
if he had a genuine concern that it was unsafe to
Right.
refill the dam, yes.
Right. And if he's testified that not passing the 1/2 PMF was a genuine concern, as the dam safety engineer implementing part 315, then the permit should not have issued under your process, correct?
If his testimony was that it would be unsafe to refill the summer elevations, I agree we would not have issued that permit.
That's not what you said in your deposition, and it's not what you testified here today, so I'm confused. If I understood your testimony correctly, you testified that if anyone at dam safety had a genuine concern, that was your phrase, genuine concern, right?
Yes,
Okay. And if he's testified that not passing the 1/2 PMF was a genuine concern to him, then the permit under your process that you've testified should not have issued.
okay. Well, I apologize. I'm not trying to be difficult, but I'm a little confused on whether he actually testified to that or if this is a hypothetical situation referring to the process. If dam safety unit raised a concern that it was unsafe to raise the lake to summer elevations under the 307 order, then I don't believe we would have issued the permit. I think that's consistent with what I've said.
Okay, and fair enough. You would not make the determination whether passing or failing a 1/2 PMF was a genuine safety concern, would you?
I would not.
That's not your job.
That's correct.
It's not within your realm of authority or expertise.
That's correct.
The person you would rely upon to make that determination was Luke Trumbull.
Yes,
And if he made that determination, you would rely upon it.
Yes,
That's true for the 2020 permit pending for the Wixom Lake elevation of the Edenville Dam levels, right?
yes.
Thank you very much, sir. Nothing further.
Thank you. Before we pass to Mr. Gamble, Ms. Holman Road, based on other planners council's questions, do you have any follow-up questions? All right, thank you. And I know that's not exactly according to Hoyle, but I'm just trying to, be efficient so that you can examine based on the entirety of the questions. All right.
Thank you, Your Honor.
Thank you. Mr. Rudolph will now have questions from Mr. Gamble. Mr. Gamble?
Mr. Rudolph, you testified previously about observing in 2018, shortly after FERC revoked its license for the Edenville Dam, that you observed that Boyce Hydro had drawn down Wixom Lake quite a bit. Is that right?
Yes,
Did you contact Boyce Hydro and threaten them that they needed to return Wixom Lake to its normal level or else Eagle would sue them for natural resource damages?
no,
Did you contact them in any way to try and pressure them in 2018 to return Wixom Lake to its normal level?
no, I did not.
Amy, could you please bring up defendant 32?
Is that the?
Defendant 32.
I'm still on the digital ones. I'm still operating under. Oh, there we go. Okay. Nice. What page?
The second page.
Thank you.
Oh, I
Do we have
apologize.
it?
First page.
You got it? He's on defendants 3-2. Yep.
Amy, could you highlight that? Well, actually, could you highlight the whole bottom email there showing who it's from? Mr. Rudolph, do you see that this is an email from Lee Moeller written on September 25th, 2018?
Yes,
And you see that Mr. Moeller is writing to someone named Dave and explaining that they need to lay off their staff, which will mean that they need to lower the level of Wixom Lake. Do you see that?
yes,
Were you involved in this email chain at all?
no,
Were you aware of this conversation between Lee Moeller and Dave Kepler?
no,
Amy, could you release that? And yeah, go ahead, Amy. And then Dave Kepler responds in those highlighted portions. He says, on water level, want to discuss both what is needed through winter and how we bring it up in the spring. Do you see that?
yes,
And had you contacted Dave Kepler to threaten him or advise him that Eagle was going to sue over natural resource damages if Dave Kepler didn't try and get Lee Moeller to return Wixom Lake to its normal level?
no,
He says on that last line, has DEQ and DNR engaged? Do you see that, Mr. Rudolph?
yes, I do.
Okay, let's go up to the top email to see how Mr. Moeller answers that question. Could you highlight the top one, Amy? Thank you. In the orange highlight, Mr. Rudolph, his answer was, there has been no interaction with either MDEQ or MDNR as of today. Do you see that?
Yes, I do.
Is that consistent with your memory? You don't remember interacting with Boyce Hydro in September 2018 on this issue, right?
I do not recall that, no.
There's no indication in that email Actually, never mind. Let's just move on. Amy, could you please bring up plaintiff's exhibit 5-6? Mr. Rudolph, when Boyce Hydro lowered Wixom Lake in the fall of 2018, do you recall that causing concern to people who lived on the lake?
Yeah, yes.
This is 5-6.
Yes, plaintiff 5-6. And are you aware that people who lived on the lake or who were in the community contacted government offices trying to see if there was something the government could do to get Lee Moeller and Boyce Hydro to return Wixom Lake to its normal level? Do you remember interactions like that with members of the public?
Yeah, I don't remember specific interactions. We did obviously we had contact from the public with concerns about the lake level. Obviously, they reached out to their elected representatives.
And Ms. Almonroad asked you about this document, about whether the state of Michigan was considering whether they could order Wixom Lake back to its normal level. Do you remember that discussion?
Yes.
What did Kim Fish conclude was the answer to that question? Amy, could you highlight the middle there? Magnify.
That we lack the authority to order the lake level to be raised.
So based on your recollection, staff talked about the issue and concluded that they didn't actually have the authority to do what the public was asking them to do, right?
Yes.
Amy, could you please bring up plaintiff 4-7? Could you just magnify the to, from, and then the first two paragraphs? Thank you. Mr. Rudolph, you're not on this email. I recognize that, but do you see that it's an email from Kyle Krieger dated October 16th, 2018?
Yes.
And then Mr. Krieger says, right now it's uncertain about who, if anyone, has the ability to correct the situation at Wixom Lake since FERC pulled the license from Boyce. Do you see that?
Yes.
And then he says, as I understand the situation, the DNR does not have the authority to require them to change the lake levels there. Do you see that?
Yes.
Is that consistent with your memory?
Yes.
And then the final sentence, he says, DEQ has indicated that without a legally established lake level, they do not have the power to direct Boyce Hydro to return the pond to normal elevations. Do you see that?
Yes.
Is that consistent with your memory as well, Mr. Rudolph?
Yes.
Amy, you can drop those. Ms. Almonroad also asked you about litigation that Eagle had filed against Boyce Hydro in 2016 about wetland and floodplain impacts. Do you remember that?
Yes.
And Amy, could you bring up plaintiff 6-9? And you had testified that you had asked for DNR staff to calculate potential natural resource damages in case they could be used in that current lawsuit. Is that correct?
Yes.
Amy, could you highlight that? Could you do the to, from as well? Thank you. So you can see this is oh yeah, there we go. You can see this is an email from Eric Decker dated November 2018. Do you see that, Mr. Rudolph?
Yes.
And he says, hey, everyone, December 12th, 2018 is mediation with Boyce Hydro LLC. Do you see that?
Yes,
Is that mediation related to that 2016 lawsuit that Eagle had filed against Boyce Hydro?
yes,
Did you participate in that mediation?
yes,
Did Eagle actually raise the muscle damage issue in that mediation?
no,
So you had asked staff to calculate potential natural resource damages in anticipation of possibly raising it in the mediation. Is that right?
that's correct.
But ultimately, Eagle decided not to. Isn't that right?
That is correct.
During that 2018 mediation, did Eagle try to leverage the muscle damages as a way to force Boyce Hydro to return Wixom Lake to its normal level in the spring of 2019?
Sorry, my apologies. No, we did not.
That muscle damages didn't even come up in the course of that mediation, did it?
No, I don't believe so.
Amy, could you go to D49? Amy, could you scroll through this a little bit? Mr. Rudolph, as Amy is scrolling through Defendant's Exhibit 49, is this a document that you prepared?
No,
And this document refers to negotiations between Boyce Hydropower and the Four Lakes Task Force. Were you involved in negotiations between those two parties?
no,
Did you ever contact Boyce Hydro and say, you have to negotiate with the Four Lakes Task Force to sell the dam, or else we're going to sue you for natural resource damages? Did that type of conversation ever take place?
no,
What about Dave Kepler with the Four Lakes Task Force? Do you know who he is?
I do.
Did you ever contact Dave Kepler with the Four Lakes Task Force and say, you have to agree with Boyce Hydro to return Wixom Lake to its normal level, or else we're going to sue you for natural resource damages? Did you ever say that to them?
No,
Were you even a part of this letter of understanding between Four Lakes Task Force and Boyce Hydro?
I was not.
Amy, could you go back up to the top and magnify that highlighted? Can you see, Mr. Rudolph, that in this letter from Dave Kepler to Lee Mueller, he's explaining their negotiations, and that as part of those negotiations, Boyce Hydro would begin the process to bring up the lake level for Wixom Lake. Do you see that?
Yes,
Did you compel Dave Kepler to make this agreement with Lee Mueller?
no,
Were you even aware that they were talking along these lines?
I was not.
Amy, could you bring up Defendant's Exhibit 50? And magnify those top parts there. Just magnify the whole top third. Okay. Mr. Rudolph, do you recognize this is an email from Lee Mueller to Ron Heilig and Greg Ohl at Boyce Hydro?
Yes,
And he refers in the subject line to an agreement to start raising pond level at Wixom Reservoir. Do you see that?
yes,
And it's dated April 2019. Do you see that?
yes,
Is this an agreement that Boyce Hydro had with you at Eagle?
No,
In fact, he says, I have made arrangements with the Four Lakes Task Force to start refilling the Wixom Lake Pond to normal summer operating levels beginning tomorrow. Do you see that?
yes,
So Mr. Mueller had given directions to his staff at Boys Hydro to begin refilling in April 17th, 2019, right?
yes,
It doesn't say anywhere that he was being forced to undertake this because Eagle was threatening him with a lawsuit, right?
it does not.
And so if you could keep in mind that date, April 17th, 2019, as we look at the next exhibit. Amy, could you please bring up plaintiffs 102? Do you recognize this as a permit issued by Eagle on May 16th, 2019, Mr. Rudolph?
Yes,
So that's about a month after Lee Mueller had already directed his staff to return Wixom Lake to its normal pool level, right?
yes,
And this is in the authorized activity box. This is a permit to quote, refill Wixom Lake back to the normal summer pool elevation, right?
yes.
And so could you scroll to the bottom, Amy, to see who signed it? Or at least to the next page? Sorry, I meant page 2. Page 3. Thank you. Is Angela Cleary on your staff, Mr. Rudolph?
Not any longer. She was at the time.
Okay, so back in May 2019, she was, right?
Yes,
So Mr. Mueller asked for a permit to do something that, as far as you can tell from the documents you've reviewed just now, he had already accomplished, right?
that's correct.
So he was controlling the level of Wixom Lake, whether he got a permit from Eagle or not, right?
That's correct.
Amy, let's skip ahead to plaintiff's exhibit 118. Later in 2019, Four Lakes Task Force and Boyce Hydro, they submitted an application to Eagle to temporarily lower Wixom Lake over that winter and then return it in the spring of 2020. Do you remember that discussion?
Yes,
Do you remember reviewing the application that Boyce Hydro and Four Lakes Task Force submitted?
yes,
Amy, could you bring it to page 11? And just highlight some of these or magnify the first one. So according to that application they submitted in the fall of 2019, they just wanted this to be a one-time event over the winter that was temporary, right?
yes,
They weren't suggesting that this would be a permanent drawdown of Wixom Lake for safety reasons, were they?
they were not.
So their drawdown, they were suggesting that it would start in early November 2019, right?
Yes,
And Amy, can we go to the next page and magnify that highlight? And then they would begin the refill in March of 2020, right?
yes,
So their plan from the very beginning, when they filed this permit application, was to return Wixom Lake to its normal level in the spring of 2020. Isn't that right?
yes.
So you were asked some hypothetical questions earlier, so I'm going to ask you a hypothetical question.
Can I just have a minute?
Oh, of course.
Thanks. Please proceed.
Thank you, Your Honor. So, Mr. Rudolph, I'm going to ask you a hypothetical question. If instead of the permit that Boyce Hydro, or excuse me, if instead of the application that Boyce Hydro actually submitted, what if Boyce Hydro had submitted an application to permanently lower the level of Wixom Lake because their engineers had advised them they needed to do that until they could increase the dam's spillway capacity, okay? So in that hypothetical situation, would you have reviewed that matter with Luke Trumbull?
I believe so, yes.
And if their engineer had provided that explanation and shown it would be unsafe to maintain Wixom Lake at its normal level until the dam could maintain, or excuse me, until the dam spillway capacity increased, is that a permit application you would have granted?
I believe so, yes.
Because when it comes to any conflict between public safety and environmental concerns, public safety wins, right? From Eagle's perspective?
Yes.
I mean, Eagle wouldn't do something that they thought endangered the public, would they?
No,
Their purpose is to serve the public, isn't that right?
that is correct.
So back to reality though, in terms of the application that was actually submitted, it didn't say any of that, did it? It was just a temporary drawdown over the winter. They were going to return it in the spring of 2020, right?
Yes.
Amy, could you bring up Defendant's Exhibit 5-9? Mr. Rudolph, can you see that this is a press release dated September 2019 from the Four Lakes Task Force?
Yes.
And in the release, they're announcing that their intent is to temporarily draw down the water of Wixom Lake over the winter and then return it to the normal level in spring 2020. Do you see that, Mr. Trumbull? Amy, maybe if you magnify that third paragraph.
Yes, I do see it.
Okay. So Eagle ended up denying that permit application for the winter drawdown, didn't it?
Yes.
But if Eagle had granted the permit application, Boyce Hydro and Four Lakes Task Force still would have returned Wixom Lake to its normal level in the spring of 2020, right?
That's what this document says.
The permit application had nothing to do with the level of Wixom Lake in the spring of 2020, as far as you could tell, right?
That seems to be correct.
Amy, could you bring up Plaintiff's Exhibit 148?
What was that last one?
That last one was Defendant's Exhibit 5-9.
Thank you.
And this one is Plaintiff's Exhibit 148.
Thank you.
And when the spring of 2020 arrived, Boyce Hydro and Four Lakes Task Force, they did submit a permit application to Eagle to return Wixom Lake to its normal level in the spring of 2020, didn't they?
Yes,
That was their plan all along, wasn't it?
that seems to be correct.
Did Eagle and DNR force them to carry out the plan that they had made in September of 2019?
No,
Did they ever come to you and say, hey, I know in September 2019, we said we were going to return Wixom Lake to its normal level in the spring of 2020, but we can't do that because we think that would be unsafe. Did that ever happen?
no.
Amy, could you scroll down to the next one? Could you highlight the lowest bank of, magnify the lowest bank there of highlights, Amy? Nope, highlight it. That one, thank you. And Boyce Hydro and Four Lakes Task Force, they also had Spicer Group on this permit application. Do you see that, Mr. Rudolph?
Yes,
Do you work with Spicer Group in your job duties?
yes,
They're an engineering firm, right?
yes,
And so Boyce Hydro and Four Lakes Task Force, they had an engineering firm on their application to return Wixom Lake to its normal level in the spring of 2020, right?
yes,
They did not indicate anywhere in their application that that would be a dangerous thing to do, did they?
no,
And did you circulate this application to the Department of Natural Resources for comment?
yes,
Was that typical? Was that a typical thing you would have done in that circumstance?
yes.
And Amy, could you bring up P151, plaintiff 151? Could you scroll down, please? Oh, page 2 is what I meant. Could you magnify the email from Jessica Mistack to Brian Rudolph? Bring the whole thing up. Could you highlight the last full paragraph starting with lastly? Thank you, Amy. So do you see that this is an email from Jessica Mistack to you on April 1st, 2020?
Yes,
And the subject line is draft refill permit for Wixom Lake. Do you see that?
yes,
So in this highlighted language, is DNR pressuring you to hurry up and grant that permit for the sake of mussels?
no,
It's the opposite, right? She actually says that DNR is reluctant to allow the refill to occur, right?
yes.
As far as you know, DNR would have been fine to just leave Wixom Lake drawn down, right?
I guess, as far as I know.
And so you don't have a memory of Jessica Mistack or anyone else from DNR saying, Eagle, you've got to grant this permit to make sure that Wixom Lake is returned to its normal level for the sake of mussels, right?
No, they did not.
And you confirmed in your testimony earlier today that you are not a dam safety engineer, is that correct?
That is correct.
And Mr. Trumbull or anyone else at Dam Safety, none of them identified any safety concerns with returning Wixom Lake to its normal level, did they?
No,
Amy, could you pull up defendant 80? Amy, could you highlight that or magnify the top email? Thank you. Brian or Mr. Rudolph, do you see that this is an email from Lee Mueller to Dave Kepler on April 8th, 2020?
yes,
And the subject line refers to a MDEQ or Eagle Reservoir Level Permit. Do you see that?
yes,
And Mr. Mueller refers to, in this highlighted language, him agreeing to sign this permit that he thought contained defective and inappropriate conditions. Do you see that?
yes.
Did Mr. Mueller ever contact you in April 2020 and tell you that he thought the draft permit contained defective and inappropriate conditions?
No, I have no recollection of that.
Were you aware that Mr. Mueller and Dave Kepler were negotiating among themselves about whether Mr. Mueller would sign the permit?
No,
And then Mr. Mueller refers in that second sentence to a Four Lakes Task Force commitment letter. So let's scroll down to that letter, Amy. Mr. Rudolph, you see that this is a letter dated April 8th, 2020 from the Four Lakes Task Force to Lee Mueller.
Yes.
Were you involved in the preparation of this letter?
No.
Were you aware that Four Lakes Task Force had agreed to indemnify Boise Hydro regarding certain provisions of the April 2020 refill permit?
No.
This just didn't involve you at all, as far as you can remember, right?
That's correct.
And Amy, could you bring that back up again? So in the highlighted language, it refers to items in the permit. Do you see the letters G, L, R, S, T, U, V?
Yes.
Okay, we're going to toggle back and forth between this document and plaintiff's 154. So we won't try the double screen. Let's just toggle. Is that easier? No, let's not try it. Okay, if we can scroll down, Amy, to the next page. And then the next page. Mr. Rudolph, do you recognize this exhibit as the permit that Eagle issued to Boise Hydro to refill Wixom Lake in the spring of 2020?
Yes.
And Amy, could you magnify paragraphs 7, 8, and 9 for us?
Excuse me.
Mr. Rudolph, once you've had a chance to review these permit conditions, could you please just explain to us what was meant by these permit conditions, what their purpose was?
So condition number 7, I believe, was actually included language within the application itself and refers to requirements within the 307 order relative to refill rates and elevations. So that just refers to what they requested to do in conjunction with the 307 order. Condition number 8 really simply says they just have to be in compliance with the 307 order. The authorized activity has to be conducted in compliance with the court order under Part 307. And condition number 9 simply says that they have to have a permit in the future if they're going to conduct another drawdown.
And condition number 9's reference to getting a permit in the future, is that required by Part 301, Mr. Rudolph?
Part 301 requires a permit to enlarge or diminish an inland lake or stream. Yes.
Is that a requirement that uniquely applied to Boise Hydro at the time?
No.
It applies to everyone, right?
Yes.
And why did you feel like you had to include condition number 9 with Boise Hydro?
Past history had demonstrated that Boise Hydro has a history at that time of conducting activities without granting permits first.
Hold on. How long?
8 minutes.
Oh, okay. Go ahead. You get on that? Would you like to take a recess?
Oh, I'm
8. I thought you said
8.
I said 80. If he had said 80, I would not be asking you.
The judge would not have been nearly as satisfied if I had said 80. No.
At this point, do you expect some redirect?
Yes, you are.
Okay, why don't we take a recess? Let's okay. Mr. Rudolph, we're mere mortals here and need to, particularly me, I need to take a recess about every 90 minutes or so, or I'm not paying enough attention. But we appreciate your time and your testimony, but we are going to take a recess for 15 minutes. Please don't discuss your testimony with anybody there in the building, wherever it is you're located in Bay City. And we'll reconvene at, let's see, Verizon says on my, it's 10:05, so we'll reconvene at 10:20. All right? Any questions?
No, sir.
All right. Anything from anybody before we recess for 15 minutes? All right. Thank you. Court is in recess until 10:20. All right, let's see if this battery powered pencil sharpener works. And the answer is no, which is what I was pretty sure it was the last time I had case file here. We've got a dandy one downstairs. That's electric. All right. Thanks. They're still here, right? We have two other lawyers. Okay. Well, that's somebody go lasso them. We're almost ready, Mr. Rudolph. Trying to find a couple of lawyers. One can never have too many trial attorneys. Just telling my staff when I was, or just when Seacock and I were in the circuit court together, a full trial week would be 8:30 to 1 on Monday. And then from 1:30 to 5, we'd do criminal sentencings. And then Tuesday would be a 8:30 to 5 day. And then Wednesday, 8:30 to 1, because we'd then have criminal status conference and plea hearings from 1:30 to 5 on Wednesdays. Thursday would be a full day like we're doing. And then Friday would be motion mornings. And so it's I'm glad we're able to do the 8:30 to 5, but I'm not the one asking questions on a regular basis. And I'm still tired at the end of the day and 8 days into it. And I can only imagine the lawyers, and I appreciate everybody's diligence and continued focus. It's I won't say it's a Herculean effort, but it's a lot of work. Ton of work has gone into it and continues to. So thank you. So Mr. Rudolph, even if the lawyers or my questions don't make sense, believe me, we're trying. So anyway.
I believe you, Your Honor.
So we'll now continue. I think we've got a full slate of counsel on both sides of the diamond. So we'll continue to the rest of the inning.
Thank you. Amy, could you bring back up what we had before, plaintiff 154? And then go down so we can see those conditions. I think it's page 3. And then magnify 789. Mr. Rudolph, when we left off for the recess, I think you were saying that the past history with Boyce Hydro is that they would often do work that required a permit without actually getting a permit first. Is that what you were saying?
Yes, essentially, yes.
So the reason that you felt like paragraph 9 needed to be in there was simply to remind Boyce Hydro that they actually needed to get a permit if they wanted to do a drawdown in the future, right?
That's correct.
And that's a law that applies to everyone. This wasn't something special just for Boyce Hydro, right?
That's correct.
And for Part 307 orders, is it your experience that those Part 307 orders often have like an operating band within which the level of a lake can be lowered or increased?
It varies from lake to lake, but it's not uncommon to have a summer and winter level.
So the Part 307 order for Wixom Lake, it did have a summer and a winter level, right?
Yes,
And in that situation, would Eagle require people who are operating the dam to get a permit just to set the lake to the levels authorized by the Part 307 order?
no,
No, because that's something that is common. It's already authorized by Part 307. So Eagle's position on that is that if you're within the Part 307 order, you don't need to get a 301 permit, right?
correct.
And so the reason that Boys Hydro would need to get a permit is simply if they wanted to go outside the levels authorized by the Part 307 order, right?
That's correct.
Amy, could you bring up plaintiff 134? One of the attorneys earlier today showed you this email between you and Dave Pingle dated December 11th, 2019. Do you remember reviewing this email?
Yes,
Amy, could you magnify that first highlight?
What is this? Plaintiff's what?
Plaintiffs 134. You mentioned that you didn't think you'd be able to get access to Boys Hydro's property. Is that correct?
that is correct.
Is that because you couldn't just walk on to Boys Hydro's property anytime you wanted?
You could not. That's correct.
You would need to get permission because it was private property, right?
Yes,
This wasn't a state-owned dam that you could just go and tour and walk around on anytime you wanted, right?
correct.
And you didn't think that Boys Hydro would give you access to their property, did you?
I did not.
I need them to pause a second.
Okay, hold on a sec. Ms. Road, would you like, I've cough lozenges down in my chambers. I'm not, I could ask Mrs. Thomas to bring some up or.
I appreciate that, Your Honor.
Okay, nope, when I get a cough, they're often not helpful, but I thought I'd at least offer. You're welcome. I'm sorry you're having a little, as my mother used to say, a frog in your throat. I'm not exactly sure where that came from, but sorry that's going on. You're welcome.
It's a power.
Did I do something?
No, probably, but.
Did you hear what you said?
Sorry, what can I say?
How many years would it take? Too long. Okay.
Okay, voila, it was me.
Oh, no,
And
I'm
not
sure it
your-
must have been me, Missy Cock. I'm sure. Couldn't possibly have been you.
It's my little extra thing.
In all seriousness, what do you want? I've got a power cord here, probably is.
I'm just wondering if there's anything, well, here, I'll take this one out. My apologies. Anya, there's a gremlin.
No.
That was my,
Oh, okay. I
That
just
was me.
want to make sure you're not connecting to. Okay, all right. I don't want anybody electrocuted.
for sure.
It looked like you were going into two different plugs.
Oh. You make sure. I put it down here.
I think you missed the part, Ms. Heacock, where I talked at the beginning of this trial about doing plumbing right before the trial started. Demonstrate my electrician's credentials.
Just wanted to tell me that anything. Exactly. Right. Plugged in, okay.
Good? So
Thank
far?
you. Yes.
All right.
Pardon.
Continue, council.
Thank you. So, Mr. Rudolph, magnifying this other highlighted language at the bottom of page 1 of Plaintiff's Exhibit 134, did you have a chance to review that, Mr. Rudolph?
Yes.
Could you help us understand the difference between either an enforcement notice or violation notice on the one hand and an order on the other hand? Oh,
Yeah, so our compliance enforcement process is bifurcated, for lack of a better way to look at it. When we're working with individuals who have come out of compliance with the state law at the district level, our goal is to try to achieve voluntary compliance, get folks back into compliance with state law. One of the very first things we do once we've determined there's a violation of statute is to send out a violation notice. And there are a variety of different types depending upon the violation of statute, the severity of the violation, and so on. So the violation notice in and of itself is generally, it's generated by the district offices. Once we get to a point where it's fairly obvious we're not going to gain voluntary compliance at the district level, we will refer the issue to the enforcement unit in Lansing. Enforcement unit still pursues voluntary compliance in much the same way, but that's all they do. In the district offices, we're still handling both compliance and permitting issues. So when it becomes obvious we aren't going to be able to make resolution in a district level, we'll refer it to the enforcement unit in Lansing. And it's sort of the same mechanism. The enforcement notice is what, generally speaking, enforcement unit would send out. So reality, not a whole lot of difference between the two. It's just where they're generated for the most part.
and is there a difference in Eagle's enforcement procedures between either an enforcement notice and violation notice and an actual order, like an administrative order that it issues to somebody?
So neither a violation notice or an enforcement notice is an order. They both seek to gain voluntary compliance. In my experience through the department, administrative orders come through things such as a consent judgment or a consent agreement, but they're actions of the court once things have been escalated, typically to the Attorney General's office. But violation notices and enforcement orders, or enforcement notices, excuse me, seek to gain voluntary compliance.
So when you sent out the enforcement notice in December 2019, that wasn't actually an order to Boise Hydro. It was a notice seeking voluntary compliance. Am I understanding that correctly?
That's correct.
And you wanted to give them an opportunity to come into compliance with the law, right? That's what it said.
That is correct.
And you also wanted to give them an opportunity to mitigate damages they were causing, right?
Yes.
What's the purpose of giving them an opportunity to mitigate damages?
Well, again, we're seeking voluntary compliance. We wouldn't want somebody to continue in an action that would compound damages to the natural resources of the state. So by giving them the opportunity to come into compliance, reduce those damages, theoretically in the future, if you ended up in court, it would reduce whatever liability they had.
So if you're going to sue them later on in the future, you want to give them an opportunity to mitigate the damages, let them know the damage is taking place, give them a chance to change course, right?
Yes.
And you mentioned before that Boyce Hydro would often act without getting permits first from Eagle. Is that right?
They had a history of acting without having permits, yes.
They would typically just kind of do what they wanted without getting the permit first, right?
That's a correct statement, yes.
And in fact, that occurred in the spring of 2018, or excuse me, the spring of 2019, when they went ahead and refilled Wixom Lake because of the arrangements they made with the Four Lakes Task Force a month before they even got a permit from Eagle, right?
That is, yes, that's correct.
Is it fair to say that Eagle's permitting decisions were not something that controlled Boyce Hydro's behavior?
That is fair to say, yes.
And in fact, when you did send an enforcement notice in December 2019, Boyce Hydro did not change course, did they?
They did not.
Mr. Rudolph, did any Boyce Hydro employees report to you for their job duties?
No,
Did you direct or have the authority to direct any Boyce Hydro employees how to do their job duties?
no,
Did you have the authority to go onto Boyce Hydro's property and direct the operation of the Edenville Dam?
no,
Did you ever do that?
no.
Could you even operate the equipment of the Edenville Dam if you had the opportunity to do so?
I could not.
That's just not something that is in your job description, right, Mr. Rudolph?
That is correct.
Did Eagle ever issue an order to Boyce Hydro mandating that they maintain the normal summer level of Wixom Lake?
No,
That's all I have, Your Honor.
We have just seconds. Ms. Omenroad? Thank you. Thompson? Thank you. May the witness be excused. Ms. Omenroad? Mr. Thompson? Mr. Gamble? Thank you. Mr. Rudolph, thank you for, pardon me. Thank you for your testimony here today. You're excused from any further testimony in the case. If either side of lawyers determine that while the proofs are still open, they'd like to hear more from you, someone will contact you. Understand?
yes, sir. Thank you, Your Honor.
Okay, thank you. And I assume both sides have the means to contact the Mr. Rudolph if necessary. Is that right? Okay, all right. Thank you. Have a nice day, sir.
Thank you, you too.
Thanks. Appreciate it. All right. Plaintiffs.
That's our last witness. We would like to read into the record, there's 10 very brief stipulations that are part of the joint pretrial order or joint pretrial submission. We'd like to read those into the record and then go through the exhibits that are agreed to and into evidence before the rest of the case.
All right.
But that's our last witness.
So, do you agree, Mr. Thompson?
Yes.
Ready to proceed with that?
Yeah, that's right.
Okay. All right. Plaintiffs, you may proceed.
Thank you, Your Honor. The joint final pretrial statement contains 13 stipulated uncontested facts that we would like to introduce into evidence. I have a copy of the pretrial statement for Your Honor if you'd like. It's pages 5 and 6. And we can simply mark this to have an exhibit to memorialize it, or I can attempt my best grammatically entertain.
I would like it as an exhibit, but you can also read it. You can just write it in hand, just the old fashioned way, before we had stickers, before we had computers. Plaintiff's exhibit 477 or whatever we are on. Hold on. Oh, we actually do have exhibit stickers. Defense, do you have a copy?
Yes, Your Honor. We joined this meeting.
Oh, it's a, all right, thanks.
Approach.
Please, thank you.
It's filed on the docket.
Oh, right, okay. So we're entering as plaintiff's exhibits 431, that which was already filed, the joint final pretrial filed December 12th, 2025, uncontested facts, starting page 5, paragraph C, subs, and then enumerated paragraphs Arabic 1 through Arabic 13. We're agreeing that those are uncontested facts, correct?
And in evidence, that's correct.
And in evidence. Jill, do you agree with that statement?
Yeah.
Mr. Juan, do you agree on behalf of your clients?
Yes.
Okay, all right. The court accepts those facts in paragraphs, sub C, paragraph 1 through sub C, paragraph 13 are admitted into evidence. Thank you. What else?
I would like to go through the stipulation.
What do you recommend?
I would propose that Paulina walk you through the binder so you understand what the guys are, if it's worked hard to put it all in.
Okay.
Good morning.
Morning,
May I approach?
please. Thank you. Thanks. Just. Okay, ready.
So the binder I just handed you memorializes all the stipulations of trial exhibits up to this point at the close of plaintiff's proofs, with the exception of 431 that was just marked.
Okay.
We've got the wholesale admission of exhibits listed as Exhibit A in the binder, which is a numbered list of all exhibits that were stipulated to from our
You know,
original
I'm
exhibit list.
I'm gonna ask that my law clerk come up here, have a seat, and we're gonna be working on this together for a while. Elizabeth, chair over. Please. And for the public review, I'm not surrendering or abdicating my authority or responsibilities as a judge in the case, and I don't want the digital memorialization of this to suggest that I am, but she will be helping me as I go through my duties. So that's why I wanted to be able to look at this. Okay. All right. Please go ahead.
Okay, so Exhibit A to the stipulation in the binder is a list of exhibits for both parties, plaintiffs and defendants exhibits that are stipulated to.
All right.
We have also stipulated to the admission of a modified and redacted version of Exhibit 345, which is in your binder as Exhibit B.
Okay.
During the course of the trial, the parties also agreed to substitute Exhibit 250 for a different document, which is in your binder as Exhibit C.
Thank you.
Last week, the parties also stipulated to admit the expert declarations and rebuttal reports of Dr. Alan Marr and Bill Sturdivant. Those are included in the binder as exhibits E and F and G and H. And they're on our list now as exhibits 419 and 420 for Dr. Williams and 421 and 422 for Dr. Marr.
All right. What is exhibit D as in David?
Exhibit D is a list of exhibits that were reviewed by Bill Sturdivant.
Thank you. So now, what were we up to?
So that takes us through H.
Thank you.
But exhibit J are the tables that were pulled out and used in the presentation of Brian Rickles' expert testimony. Those are offered as exhibits 422.
I'm sorry, who's expert testimony, counsel?
Brian Rickles.
Oh, right. Sorry.
Those are not as exhibits 423, 423. And after that, exhibit J in the binder.
Thank you. Our weatherman.
And then finally, we may, plaintiffs may use it 429. At A in the binder, in the forthcoming cross definition of reasonable, and this has been.
All right. Okay. Both counsel agree, who have been speaking for plaintiffs at this part of the hearing, agree with what counsel's just indicated. All right. Mr. Gamble, on behalf of defendants, any disagreement with the admission of everything just referred to by plaintiff's counsel?
No.
All right. Is there anything that plaintiffs had sought to offer that is not included or addressed in this submission? Do you agree? All right. Thank you. Court admits all those documents discussed by counsel, and I'm very grateful for the substantial amount of work undertaken to memorialize this. I would note there's just in an exhibit A, for example, there are 25 pages of listed exhibits that for defendants, just to understand the magnitude of the effort of counsel, goes up to 417 for the plaintiffs and 155 for the defendants. That's just in tab A. So I appreciate very much the effort that's been gone into. As I look at all the exhibits, I'm literally, I've run out of space. So I'm trying to repurpose some shelf files. So we'll figure that out. But thank you. Anything else on the exhibits? All right. Thank you. All right. Mr. Juan, very well. Very well. Defense, please proceed. Let me just get my notes from this last witness. All right, you may proceed.
This is pursuant to Michigan Court Rule 2.504B2. Luckily, we have the benefit of the Court of Appeals opinion in this case. And they clearly outlined the elements that plaintiffs have to prove. They have to prove three elements. One, that defendants took their property for public use. Two, the government's actions were a substantial cause of the decline of the property's value. And three, that the government abused its powers in affirmative actions directly aimed at the property. Now, at this point, they can't just rely on allegations. They've had their chance to put on their case. They must have submitted evidence to meet their burden of proof as to these three elements. And for purposes today, we believe that they have failed to offer any evidence as to two of those elements, and therefore this case must be dismissed at this time.
Okay. Which elements, please? Which elements? You said two.
The first one, we're going to focus on that defendants took their property for public use. And the third one, that the government abused its powers in affirmative actions directly aimed at the property.
Okay, please proceed.
With respect to the first, which is really the takings part of the case, plaintiff's theory is that via their operational control of the dam, the defendants took the dam for public use in their pursuit of environmental protection. Now, a showing of operational control is necessary to meet the public use requirement. Not just a showing that they could have exerted operational control. These are the takings claims. They have to show that state defendants affirmatively assumed operational control of the dam so it could be put to public use. And that's the Court of Appeals opinion at 191. There's two reasons why plaintiff's claims on this element fails. First, there is absolutely no evidence that the state defendants took control of the dam in any manner or that they required Boyce Hydro to return Wixom Lake to its normal level in the spring of 2020.
Hold on. Gravity.
Like movement.
Okay. All right. Go ahead, please.
Boyce Hydro was the owner of this dam. Four Lakes Task Force was the entity that was in negotiations to purchase the dam. And yet, in this case, we have not heard any testimony from any employee of Boyce Hydro or the Four Lakes Task Force. There is no testimony from Boyce or the Four Lakes Task Force that the state defendants took over operational control of the dam. There's no testimony from any Boyce or Four Lakes Task Force employee that the state ordered Boyce to raise the water to its normal level in the spring of 2020. And in fact, all the evidence that has been submitted so far is that Boyce Hydro raised the water to its normal summer level in the spring of 2020 because of its contract with the Four Lakes Task Force. Period. End of story. That is all the evidence that has been submitted on this point. The only thing the Eagle did was to issue a permit that was requested by Boyce Hydro so that the water could be raised to its normal summer level. That permit did not require Boyce Hydro to raise the water. That was purely optional. Boyce Hydro made the decision to raise the water to its normal summer level in the spring of 2020.
We've heard a lot of questions about natural resources protection, notices of seeking a $300 million natural resources penalty or fine or assessment. Can actions such as those allow the plaintiffs to satisfy their burden on theories or on elements 1 or 3?
Under element number 3, I will get to that point. And I'm also going to address it in just a second as to why the natural resource damages claims can't show operational control.
Okay.
Right now, I'm just focusing on there's a complete lack of evidence on showing that Eagle or DNR took operational control.
Right.
For
And
public
what
use.
my question, I guess, is, counsel, is can an entity, whether it's a state in this case or some other organization in a hypothetical, can an entity or person do things that are so substantial that it causes another person to do something, even though they don't mechanically take action? Let's say I run an auto body shop and the party who holds the secured note has certain performance requirements, whether it's accounts receivable, inventory, whatever. Can, in that hypothetical, can that entity so influence the property owner that the entity takes control of it?
I could imagine that situation could arise, but again, they would have to show that that entity essentially pressured them to the extent or took over operational control. That you have to have a proof of operational control. Can you influence an entity so much that you take over? Maybe. But there is absolutely no evidence that that took place in this case. With respect to the natural resource damages claim, no employee from Boyce Hydro or the Four Lake Task Force testified in this case. No employee from Boyce Hydro or the Four Lakes Task Force testified that they were pressured into raising the normal level. There's a complete lack of evidence that was submitted on that. They did have, plaintiffs did offer Mr. Sturdivant's testimony that DNR was allegedly pressuring Boyce Hydro. That's what he said, but he had never talked to a Boyce Hydro employee. He never talked to a Four Lakes Task Force employee, and he couldn't point to a single document showing that they had pressured Boyce Hydro to raise the water levels. His testimony was pure speculation, and that cannot support their claim.
What is the standard that the court considers the record evidence in on 2.504B2 motion?
There has to be some evidence submitted. You can get the rule out itself, but that essentially categorizes it. They have the burden of proof. They have to show by a preponderance of evidence. I guess that's the standard, sorry. They have to show by a preponderance of an evidence that they have met their burden of proof on each of these elements.
Do I have to take the evidence in a certain light at this stage, or is it just analyzing the evidence?
I think it's just analyzing the evidence. When you asked your question, their entire, I was making the point, their entire case is based upon the issuance of this permit in the spring of 2020. We know the case law is clear that the issuance of a permit cannot support a takings claims. It does not show operational control. You can look at the Maryland Froling revocable trust case, the Hinosa v. Department of Natural Resources cases. Those are all cited in the various briefs that we've cited. That is a clear case. They have to do something in order to take operational control. Failing to act is not. Issuing a permit is not under the law. So their claim completely fails. With respect to their assertion of the natural resource damages and their claim that somehow they controlled or they used that to control Boyce Hydro. As I said, there is a complete lack of evidence to support them. No employee has testified that they felt pressured because of the natural resource claims to raise the level to Wixom Lake. And we just went over it again and again and again. All the evidence is that Boyce Hydro, when they submitted their winter drawdown permit, they said they were going to take the water down and that they were going to re-raise it in the spring. That's what they said. All of their communications show that they intended to raise the water. There was no communications indicating that they did that because of pressure exerted because of the natural resource damages. None. And frankly, I would push back on the concept that even asserting the natural resource damages claims can constitute a taking. Boyce Hydro had violated the law. It was a clear violation. There's no question. They had not sought a permit to draw down the lake. They had done it multiple times. Eagle is required to enforce the law. Under Part 301, you have to get a permit. before you diminish a lake. We had Ms. Mistack, we had Mr. Rudolph testify as to it. It's crystal clear. The fact that Eagle was requiring them to comply with the law can't be a taking. I can't find any case law that directly supports that because it's such an obvious proposition. You could potentially look at the cases saying that if you issue a permit, it's not a taking because again, the state is simply complying with the law. But it seems to be an absolutely obvious proposition that if you're just asking them to comply with the law, it can't be a taking. The second element that they failed to meet is that requirement that they have to show that the government abused its power in affirmative actions aimed at the property. Now, their theory is that the state defendants knew it was unsafe for the dam to operate when Wixom Lake was at its normal summer level. And yet they authorized Boyce Hydro to raise the water to that level by issuance of a permit and then misled the public about the risk of failure. This is a constitutional based cause of action. This is a takings claim under the Constitution. It's not just negligence. And as this court has already found, simply alleging malfeasance or in licensing or a failure to act doesn't meet that standards. And that's the court's October 1, 2025 opinion. And despite this court's warning, that's the exact case that they put on. The entire premise of their case is that Eagle shouldn't have issued this permit. And that's, again, based upon the issuance of permit, which this court has already said is not sufficient. The case law is unequivocal. That does not support their cause of action. And therefore, on that basis alone, it should be denied. Now, in an attempt to generate some affirmative action, they've argued that Eagle's decision to ignore facts indicating that it was likely the dam would fail if raised back to its normal level is an affirmative act. It's not. It's still a failure to act. It's at most an admission, and it cannot support an inverse condemnation claim. In any event, they failed to support that argument with any facts. This dam had operated at this level for 93 years. The water in Wixom Lake had never, ever, in those 93 years, come close to rising to a level that threatened the integrity of this dam. Every inspection report by FERC, every inspection report by an inspector retained by the dam owner, and even the engineers retained by the Four Lakes Task Force that was issued before this dam failed said that it was safe to operate. Every single one. The only people that have said this dam was not safe to operate are plaintiffs' paid experts. That's Monday morning quarterbacking. They have to show that Eagle knew it was likely the dam was going to fail. There's been no evidence submitted making that showing. Now, Eagle knew that the dam didn't meet the 1/2 PMF standard, but that's insufficient alone to meet the necessary intent. The dam hadn't met that standard for 93 years, never had a problem. None of the engineers said that fact caused the dam to be unsafe. There was absolutely no evidence submitted that the defendants knew that the dam was likely to fail. And we talked a lot about Part 315, MCL 324, 31516 does not require the state to take any action if a dam doesn't meet 1/2 PMF. That statute is directed at the dam owner, not Eagle. It doesn't mandate any action by Eagle. Nor does it even contemplate or state that if it doesn't meet 1/2 PMF, there has to be a drawdown. There is no requirement in the law that the defendants failed to meet. We heard a lot from Mr. Sturdivant. Again, he said, well, the state should have known or something should have raised red flag, but that's malfeasance. That's negligence. Not knowing. It's insufficient to meet their burden of proof. And then the final point that I want to make, and usually you start with your strongest point, but I'm ending with my strongest point because that's just where it works in how the elements are lined up. But this is clearly a failing on their part, which is that they have to show that the defendants deliberately misled the public. There has been zero evidence submitted by the plaintiffs on this issue. There has been no evidence that the defendants said anything to mislead the public. Not one plaintiff was called to testify here today that they were misled. The only evidence offered is that the state defendants did tell private citizens, they did tell Boyce Hydro, and they did tell the Four Lakes Task Force about their concerns that the dam could not meet the 1/2 PMF standard. Now, they argue that we misled the public by failing to tell the judge in the lake level proceedings about Eagle's concerns that the dam could not meet the 1/2 PMF requirement. And don't forget, this was what, April, May of 2019. Eagle didn't make a final determination that it didn't meet 1/2 PMF until January of 2020. So at most there were concerns at this point. But the defendants didn't have any obligations to say anything in the 307 proceeding. There's nothing in Part 307 that the plaintiffs have pointed to that required Eagle to stand up and say or express their concerns. So silence isn't misleading. Silence is an admission, and it's not an affirmative action, which is required under this element. And finally, we know, in fact, the judge was told about the spillway problems. Their contention is factually incorrect. Paragraph 18 of the petition filed by the counties plainly states that there were spillway problems that had to be fixed at the dam. And of course, the Four Lakes Task Force submitted the lake level study, which is a requirement under Part 307, and that in detail discussed the spillway capacity problems at Edenville Dam. That is a clear and absolute failing by plaintiffs, Your Honor. They have the burden of proof. They have the burden of proof of showing each element in the case by a preponderance of the evidence. They cannot prove it as to any of the two elements that I've discussed. And therefore, I would ask Your Honor to grant our motion for involuntary dismissal.
Thank you. Just a moment. Counsel.
Thank you, Your Honor. We know after 8 days of trial, I think we're at 8 days of trial, that by February of 2020, the state of Michigan Dam Safety Unit of Eagle and its lead dam safety engineer, Luke Trumbull, knew, in his own words, conclusively that the Edenville Dam did not satisfy the minimum standards for dam safety established by the clear, unambiguous,
and mandatory provisions of Part 315 of NREPA, which is the state's dam safety statute. We also know through the testimony of Mario Fusco, who was Mr. Trumbull's boss at the time, and by Mr. Trumbull's own admission, that because the dam did not meet the state's minimum spillway capacity requirements, then as a matter of state law, it was not safe, structurally sound, or hydraulically adequate under the clear and unambiguous requirements of Part 315. And so what happened after the state made that definitive determination is why we're here and why we're having this trial. The dam owner came to the state's dam safety unit and to Eagle and said, Eagle, effectively, we own a non-compliant dam. Will you please authorize using this non-compliant dam to raise the water level in Wixom Lake by about 6 feet? We know from the evidence, the scientific record, and the data in the case that by adding 6 feet of water to refill Wixom Lake at this time, they're adding billions of gallons, thousands of acre feet, putting inordinate amounts of horizontal pressure and hydraulic load upon a dam that they know does not meet the state's minimum and mandatory safety standards. If the state is properly using its statutory authority, the answer to that request to raise the water level back up should be a clear, firm, and unambiguous no. But we're having this trial because the state's answer to that request was, in effect, we know that your dam is not compliant with the dam safety statute. We know that you have not
How
built.
is that an affirmative taking of the plaintiff's property?
The roadmap established by the Court of Appeals case indicates that the act of authorization is an affirmative act. And
What part of the Court of Appeals opinion so holds? Page and cite. What's the site again?
Your Honor, the pinpoint site is 348 Mishap at 187. The full site I can give you. Okay.
What's the Court of Appeals case number, please?
Your Honor, I don't have that. I have the,
Right, not the actual citation, Ms. Ullman Road, but the COA number. It's a 6-digit number. It'll be in the caption, you know, if anybody knows.
But it is 359-315.
All right, thank you. Hold on.
Page 187, continuing on to page 188. I'm sorry, Your Honor, I do not. Mhm.
Yes, please. Where?
Your Honor, there's a paragraph beginning with the sentence, "First, Mays held that allegations." That's on one, yeah, if you're not looking at the Mishap site, sorry.
First base, held the allegation, so defendants all was.
Yep, and it continues to switch the water source for Flint residents despite knowledge of its risk was an affirmative act directed at the plaintiff's properties. In this case, defendants insist that any affirmative actions leading to the dam failure were taken by Boyce, and thus plaintiffs have not alleged affirmative actions taken by the defendants themselves. And I'll pause there to note that that's the argument that Mr. Cool has just repeated here in the state's motion. It was taken by Boyce. Boyce was going to bring the water back up all along because they had a contract with the Four Lakes Task Force to do so, and nothing that the state did in requiring them to comply with the law was an act of authorization. It's the same argument they made and was rejected by the Court of Appeals. It's the same argument legally that should be rejected here. And in addition to that, after 8 days of testimony, we now know that factually.
So your position is that this language first means held the allegations, state defendants authorize the city defendants to switch water source for residents without knowledge of its risk. It was an affirmative act directed at the properties. So you may expect a 6.75. It's case defendants insist having affirmative actions. In the dam failure, take voice, you got plaintiffs, you got not alleged affirmative action taken by the defendants themselves. It goes on about the authorization of the water source switching. Is it can the plaintiff separation in this case? The defendants authorize the release. The release of water levels these people in the clear. For cases, plaintiffs allege state defendants authorize another defendant take actions directed at the plaintiff's properties. System names, allegation, defendants authorize the raise water levels. Despite knowledge that the victim has sufficiently treated their actions. It is that language that you include stands to the proposition. The Court of Appeals has said that the authorization is enough.
That's correct, Your Honor. Yep.
Understand.
Yep. And in addition to
Thank you
that.
for that specific. I thought based on the submissions that have been submitted previously, that was your position, but I appreciate that clarity. Thank you.
You're welcome, Your Honor. It's there. And that's, we think, the roadmap for deciding this case legally. Factually, as the record has developed, we know for a fact that the water level on the day before the authorization kicked in was at what's been disputed somewhat as quote unquote run of river, but it was at 470 or just under 470 according to the evidence in the record. And so under the authorization, the state authorized them to refill Wixom Lake by adding thousands of acre feet, billions of gallons of water. And we've heard from the experts in the case who've testified, I think, very definitively, and Dr. Marr's model, in his words, said, convincingly that the additional pressure caused by that amount of water contributed to the dam failure and thus the damage to the plaintiff's property. And as for trying to make sure I'm not overly repeating myself, Your Honor. As for the evidence that Boyce would have done this regardless, there's a material disputed issue of fact as to whether that's the case, because
So what's at this stage, what is this court's responsibility with regards to disputed facts?
well, Your Honor, I was prepared to argue this motion, quite frankly, on the directed verdict standard, right? When I think that standard still should inform the court that all inferences should be drawn in favor of the non-moving parties, and the motion.
It is the court's understanding under the appellate case law of the state of Michigan, Stanton versus Datchell, 186 Mishap 247 at 261, Williamston Township versus Hudson, 311 Mishap at 276 at 289, 2015, Samuel Bagola Services versus Wild Brothers, 210 Mishap 636, 639. Angelo Iafrate, I'm sure I'm mispronouncing that, IAFRATE Company versus M&K Development Company, 80 Michigan 508, 1978. The court recognizes that Court of Appeals decisions prior, I think 1996, are not necessarily binding, but are also instructive, as well as Armadillan, ARMOUDLIAN versus Zadi, ZADEH, 1982, seem to instruct that in a 2.504B2 motion, the standard is different than that for a directed verdict in a jury trial, because 2.504 Bravo 2 permits the court to make credibility evaluations and factual findings, and the court, in determining whether to dismiss an action under 2.504B2, is not, quote, required to view the evidence in the light most favorable to a party, to resolve all conflicts of evidence in their favor, or to determine whether there is a genuine issue of material facts. See Williamston, 311 Mishap.
Yeah, Your Honor, that seems to be consistent with the language of the court rule. The language of the court rule states, in an action or hearing tried without a jury after presentation of the plaintiff's evidence, the defendant, without waiving the defendant's right to offer evidence if the motion is not granted, may move for dismissal on the ground that on the facts and law, the plaintiff has no right to relief. The court may then determine the facts and render judgment against the plaintiff, or may decline to render judgment until the close of all the evidence. Quote, if the court renders judgment on the merits against the plaintiffs, the court shall make findings as provided in MCR 2.517, which provides for findings by the court. So I think the court's options are twofold. Defer a ruling on whether to render judgment against the plaintiffs.
Sorry, what did you say?
Yeah, the court has two options. Defer, decline to render judgment until the close of all the evidence, including proofs presented by defendant Eagle and defendant DNR through their witnesses beginning today, or render judgment on the merits, which requires the court to to make findings as provided
Right,
in 2517.
right.
So I hear what the court's saying about sort of a less deferential, less permissive standard of review.
Right. I mean, I'm accustomed in civil trials for defense counsel to stand up at the close of proofs when we have a petite jury that's been excused for lunch to say, Your Honor, and then well, we have to take the evidence in light most favorable to the non-moving party and, and then immediately after I denied the motion, we would then bring the jury back for the rest of the case. But that's not the standard in a bench trial. My job is to apply the law, not to comment on the efficacy of it.
I hear that, Your Honor. And our position is that applying the facts and law in this case, the proper decision would be to decline to render judgment at this time until the close of all the evidence. Continuing on with the court's analysis in this case, Your Honor, which provides the roadmap for how to apply the law to the facts. The Court of Appeals here, also referring to Mays, said that Mays emphasized allegations that the state defendants concealed data and made false public statements about the safety of the drinking water from the Flint River. And as it applies to this case, it says similarly, plaintiffs here allege that Eagle engaged in a long pattern of misleading statements dating back to 2018, designed to conceal and obscure the dangerous condition of the dam. For instance, plaintiffs allege that after conducting a cursory inspection of the Edenville Dam in 2018, Eagle reported that the dam was structurally sound when it was not. And what we now know from the evidence presented in this trial is that after the dam failed and Ms. Clark, who was the director of Eagle at the time, reported back to the United States House of Representatives, she said that if it had been determined that the dam could not pass 1/2 PMF, as it later was determined by Eagle, the dam should have been rated in poor condition. And Eagle never changed or altered its rating or conclusion that the dam was in better condition than that after the cursory inspection. The dam safety unit, as we now know, was also present at the Part 307 proceeding and participated with the Attorney General in presenting the petition in support of the 307 lake level order. And at that time, there were definite concerns about whether the hydraulic analyses that were being completed for this dam, notably by Mr. Perkypile and then also by Eagle in conjunction with Spicer, were going to show that this dam did not meet the minimum spillway standards. And yet they allowed.
But that was alleged in the 307 petitions itself, is my recollection, that they said we're doing this partially because we have to build better spillways.
Right, Your Honor. And as we saw, the Spicer lake level study, for example, said it's anticipated that modest spillway improvements may be required. But in
one
fact,
of the witnesses yesterday said if you put a bunch of rocks and dirt on, this thing wouldn't have happened.
right, and Spicer,
So-
right, and Spicer would have known that too. I mean, it would.
But so why isn't that a modest improvement that could have prevented this terrible event?
Because it wasn't a modest improvement to the spillway.
The spillway, clearly not.
the spillway
I mean,
needed-
that's an engineering
Yeah.
project.
The spill,
We're
yeah.
not doing that with wheelbarrows and bulldozers
Or horses.
over the weekend, or horses.
Right, right. And so, Your Honor, I think that the record shows that lake level petition, definitely obscured or at least minimized and vastly downplayed the actual condition and deficiencies of this dam as they existed at the time. And moving forward, when Eagle conclusively determines in January-ish, February of 2020, that the dam does not meet 1/2 PMF, they don't go and tell Boyce and the Four Lakes Task Force of that fact either. And so they leave it. They say, we're going to wait for Spicer to come back with a 315 inspection report to tell us all of the things that we kind of already know are deficient about this dam, including its lack of ability to safely pass 1/2 PMF. But in the meantime, they get an application to refill the water level. And instead of waiting for the inspection report to come through, Mr. Strumble was asked this question, why didn't you just wait for the inspection report to come through? He paused. He said, that's a good question. And it is a good question because Eagle says itself, we need inspection reports to tell us whether it's safe to operate dams in the requested fashion or in the manner in which they're asked to be operated. And they didn't wait for the inspection report in this situation. And the rush to refill the water in Wixom Lake, knowing that the dam could not meet the 1/2 PMF, knowing that it had steep embankments, knowing that it had all these other problems, was an unsafe action to take. And so under the standards for affirmative act established by the Court of Appeals, there's at least a factual question, and the court should decline to render judgment until after close of all the evidence. With regard to this idea of abuse of powers, Your Honor, the statute, Part 315 of NREPA sets forth the scope of the state's legitimate powers with respect to dam safety. It directs the state what to do. And I'm struck by, for example, the redirect examination of Mr. Rudolph today, where the state makes a big point to say that Boyce was aware of its mandatory duties of state law and just did whatever it wanted. In the face of mandatory duties, it made up its own rules. And you heard Mr. Trumbull testify that even though 31516 sets forth mandatory preconditions for the operation of a dam that lacks spillway capacity, the state still decided to grant itself the discretion to determine that the dam was safe for continued operation anyway. And the issue is not whether the setting of a normal lake level in and of itself is inherently unsafe, but rather the use of the dam to impound a volume of water being unsafe when the defendants know that the dam does not meet the state's minimum standards for safety, structural soundness, and hydraulic adequacy, in the words of Mr. Trumbull and Mr. Fusco. And in addition to that, we've seen, a definite, clear evidence in Exhibits 135 and 142, and also the testimony, just for example, that when the state started raising issues of enforcement notices and enforcement actions against Boyce, they were also suggesting, Four Lakes Task Force, we haven't sued you at this time, but we're bringing you into this because we want to put, we believe the evidence shows, exert some pressure on you and put some muscle behind the lake level order and also our direction that we want you to refill Wixom Lake. And they did that to get leverage to maintain higher water levels.
Who is they?
The Attorney General's office on behalf of Eagle and DNR.
Thank you.
And Eagle ends up being the party plaintiff in the lawsuit that is eventually filed against Boyce. The defendants have made much of the fact that that lawsuit was not filed until after the water level began to rise up to normal pool. But Exhibits 135 and 142 at a minimum establish that the threat and the use of a multi-hundreds of $million in damages claim against Boyce was being used as leverage against Boyce and Four Lakes Task Force to give them to do that. So much so, the link between these two things, cause and effect, is shown in Exhibit 152, Plaintiff's Exhibit 152, where Mr. Kepler writes to Mr. Mueller the day before the permit is signed off on, Lee, we need you to sign off on this permit. If you get us into litigation with Eagle the way that Eagle is threatening, it's going to jeopardize our transaction to acquire these dams. And so raising the lake level, time is of the essence. And so there's a definite urge and urgency on the part of Kepler and Boyce, not Boyce, but Kepler, to push Boyce to raise the water level because the state is sitting on the permit and pushing them to do it under threat of additional litigation, which could jeopardize the whole deal. Public use, Your Honor. The Court of Appeals opinion in this case says at page 190 of the Mishap site, I'm sorry, I don't have the slip, the slip page site.
Now I have the actual,
Okay, very good.
the bound volume or the functional equivalent.
Says,
thereof.
quote, the relevant question is whether defendants took plaintiff's property by controlling the operation of the dam for a public use, not whether plaintiff's property once taken would be put to a public use. Although privately owned by Boyce, The dam was subject to public oversight by defendants. That's 348 Mishap at 190. And the Court of Appeals says that the quote, affirmative actions taken by defendants to keep lake water levels high and conceal risks contributing to the dam failure and the damage to plaintiff's properties are quote, the act of condemnation. And so the defendants have absolute authority to tell the dam operator what it can do and can't do in terms of raising or drawing down water levels. That's the whole premise behind their enforcement notice under 301. It's the whole point behind their continued discussions about what can we do to get Boyce to change its behavior and abide by the water levels that we want to be established and that other parties want to be established. It's an absolute fiction to say that the state needs to be behind the controls of the, at Boyce HQ, putting their hands and fingers on the levers of dam control. And what we know is that when the state says, use the dam, you can use the dam to raise the water, that directs the dam operator to do something very specific in terms of the operation of the dam. The dam was never designed for flood control, and the state knew that. It was designed for hydroelectric power. And so when it's decommissioned from generating hydroelectricity, the one and only way to control the water level in Wixom Lake is to raise the gates higher, which will lower the water, or lower the gates down, which will hold water back, build up water in the reservoir, raising the water level and increasing the pressure on the earthen embankment dam. And so when, in the words of the IFT report, Eagle authorizes the permit directing Boyce to raise the water level, what they're saying is lower the gates, hold back the water, raise up the depth of the lake, and they know increased pressure on the dam. And so, the law is clear from the Court of Appeals opinion, and what we now know from the facts in the record, and what we'll further establish through the presentation of the state's case, is that those operational details of the dam are exactly what the state authorized and exactly what the state knew it was authorizing to happen. As for causation, Your Honor, the expert testimony in this case so far is completely undisputed. The state has not presented a single hydrologic model to counter Dr. Williams' testimony as to where this lake level would be, given the watershed size, watershed characteristics, and volume of water where it started and ended based on his analysis. The state has not provided any evidence to refute or any model to put up against Dr. Marr's testimony from yesterday as to the geotechnical failure of the dam, what caused it, when it happened, and under what conditions that he calibrated to observed factual conditions. And up to this point, other than cross-examining Mr. Sturdivant, the state has not put any dam safety testimony into the record that would give this court a sufficient basis to make findings of fact and render judgment against plaintiffs under the standard of 2.504 B2, where the defendant has the burden of showing that the plaintiff has no right to relief under the facts presented at trial. Your Honor, this is a complex and large factual record, and it's our position that the court, under the controlling court rule, should wait until the close of all the evidence before rendering judgment based on a fulsome review of the transcripts, the exhibits, and the proposed findings of fact and conclusions of law presented by the parties.
Thank you.
Your Honor, as my friend and co-counsel, Mr. Thompson reminded me, the only thing I didn't cover at this point is the most recent testimony from Mr. Rudolph this morning that the permit to authorize higher water levels would not have been issued if dam safety concerns had been raised and if he'd been presented with genuine concerns about dam safety, including failure of the 1/2 PMF condition.
Thank you.
Yep.
Mr. Thompson, you had a proxy, but did you want to present anything? It's a substantial shadow, so.
In our presentation, we went through each of the elements that plaintiffs have to prove. They have to show operational control that was separately analyzed by the Court of Appeals in a separate section. I think it started at page 191. Again, no testimony from Boyce, no testimony from Four Lakes Task Force. They didn't show any evidence that Eagle took over operation of the dam. They want to talk about the permit being the authorization. Well, let's take a look at the Court of Appeals decision to see what they said on whether or not granting a permit constitutes inverse condemnation. Oops, sorry, I changed it. I moved my page. If you look at, it starts at page 183 and goes over to page 184.
Please proceed.
I'm quoting from the court. So to understand what allegations are sufficient to plead affirmative actions directly aimed at plaintiff's property, it helps to understand what allegations are not. 40 years ago, we held the state's alleged misfeasance in licensing and supervising a waste disposal operation did not constitute affirmative actions directly aimed at the counter plaintiff's property. Nothing in the Court of Appeals opinion changes that result. That is longstanding case law that's been held over and over and over again. And yet here we are with them asking this court to ignore that language. They talk about the Flint decision. The Flint decision, the state controlled the water system. It was the emergency managers that were in control of the city. That was the basis for the finding that the state was in control, not just authorizing a permit. There is no case law holding that simply authorizing a permit constitutes operational control. The Court of Appeals did not say that in their separate discussion of operational control. There has been a complete lack of evidence provided by defendants. They've had their chance. They've had their chance to provide evidence. What's going to be presented by the defendant is not going to bear on this. They have not shown operational control. There was also a complete failure to respond to, well, I'm sorry, not a complete failure to respond, a lack of response on whether or not the defendant said anything misleading to the public. They referred to the inspection report. That was an internal document. There is no evidence has been submitted that anybody outside of the state saw that document. There has been no evidence submitted that anybody was misled by that document. So that document cannot support their contention. They criticized what was in the petition. The petition wasn't filed by Eagle. It was filed by the counties. Any statement that may have downplayed the embankment issue was not a statement by the state. So it could not have been misleading. We heard the argument, oh, once the state determined that they, definitively that, the dam was not going to meet 1/2 PMF, they didn't tell the Four Lakes Task Force. That's what they just said. And then they quoted an email from Mr. Trumbull to Mr. Hanson, who was the engineer for the Four Lakes Task Force. So clearly, there was no misleading of the public. The fact that they, even if they take their statement as true, the fact that Eagle may not have said something to the public is not misleading. It's an affirmative action that's required. There has also been absolutely no evidence supplied that the state required Boyce Hydro to raise the lake level to its normal summer level in the spring of 2020. The permit simply authorized it. It was a decision for Boyce to do. There has been no testimony submitted that Eagle pressured Boyce Hydro, that Boyce Hydro felt pressured, or that Four Lakes Task Force felt pressured to raise the lake level to the normal level. Part 301 only prevents you from diminishing a lake level. That's what they had done. That's where the violations that Eagle was pursuing. But again, there has been no evidence. They've had their chance now. This is it. They had their time. There was no evidence submitted that Eagle required Boyce or the Four Lakes Task Force to raise the level to the normal summer level. Again, we think they failed to meet their burden of proof when we ask you to dismiss the claim.
Thank you. Matter before the court is the defendant's motion. In a bench trial, as I indicated previously, and I don't claim any authorship of that which I read, it's from the Michigan Judicial Institute's Civil Proceedings Bench Book, most recently accessed yesterday morning before at 7:57 a.m. I always found the bench books invaluable when I was a trial judge, and I find them invaluable again. This matter is governed under MCR 2.504B2 for the reasons that the court will indicate as I proceed here. The court respectfully declines to render judgment until the close of all the evidence in this case, as is provided under MCR 2.504B2. I recognize completely I have the authority, should I determine it appropriate, to do so. The basis of this decision is I have the benefit of excellent argument from both counsel, and I'm very appreciative to both counsel for that which they shared with the court. But I think just from a review of whether or not this decision is an abuse of discretion, I would just highlight to my colleagues on the Court of Appeals and the 7 outstanding justices of our court. Today is January 22nd, 2026. It's a little bit before the noon hour. This case has been assigned to me since the end of January 2024. Since January 12th, 2026, we have heard from, my notes indicate, the following witnesses, and I don't need lawyers to stand up and say, Judge, you forgot Bill, you forgot Fred, you forgot Nancy. I'm comfortable that I'm going to give the reviewing tribunals enough to get the sense of it. January 12th, Ms. Seidel, Mr. Pulaski, Mr. Fasco, January 13th, Mr. Trumbull, and then again on January 14th, Mr. Trumbull. I have just of those witnesses, and I'm sorry, January 13th and January 14th, Mr. Trumbull. I have 70 pages of notes just on those witnesses so far. Ms. Mystic testifies on January 14th, 10 pages of notes. Mr. Krieger, 2 pages of notes plus an extensive transcript. Mr. Sturdivant testifies on January 15th. I have 55 pages, or I'm sorry, 33 pages of notes. January on his direct, and then I don't even remember how many pages on his cross. Dr. Marr testified yesterday. Dr. Williams testified the 16th. Witness Rapolte testified the 16th. I stopped writing down the pages of notes. We have been provided a binder that a stipulation of the parties that there are literally hundreds of documents that have been admitted. I looked to my left and I have run out of room on the shelves to review all of the binders of the specific witness, specific exhibits. Why am I saying these things? I'm saying it because there is a lot of testimony that's come in, but I have not yet had the opportunity to review the documents in their entirety. And it would be inappropriate in my estimation to definitively rule one way or the other until I have such an opportunity. Given that there are 60 seconds in every minute and 60 minutes in every hour, I don't imagine that between now and when the case is going to be submitted to the court, if we proceed to the defendant's case on the schedule that they shared with both the plaintiff's counsel and the court yesterday through an email, and I thank the lawyers for that courtesy. There's no change. It's just, I'm not physically capable of reviewing all these documents before then. As a result, I believe it is appropriate to respectfully decline to grant the motion at this time. I will proceed to the taking of proofs should any party wish to offer proofs for the defendants in a case in chief. We'll then proceed to plaintiff's case and rebuttal, defendant's case and rebuttal until we are completed. And then after that time, the court will review the 5,000 to 10,000 plus pages of documents that I have the obligation to review, given the magnitude of the claims and the magnitude of defenses that are raised by the plaintiffs and defendants, very, very capable lawyers in this case. For that reason, the court respectfully declines to grant the motion under 2.504B2 at this time. The time is 10 minutes before 12. As I indicated, I think at the beginning of the week, I have a status conference in another case that's assigned to me on my Court of Claims docket at 12:15. I need to speak with an attorney other than Ms. Hughes about that case before that. So I'm asking, I'm telling the parties we're going to be in recess until 1:15 because I'm going to just want to take a few minutes to clear my head after that. So that's the plan. Any question? Mr. Kuhl, thank you for your motion, the opportunity for the court to review this information. Anything else on that motion before we recess for the afternoon? Thank you. Ms. Carlson, you responded on behalf of yourself and your colleagues, particularly Mr. Thompson. Do either Mr. Carlson or Mr. Thompson have anything else to address at this time?
Nothing, Your Honor.
Okay, all right. Enjoy the slightly elongated lunch hour and we'll see you at 1:15. Thank you. Court's in recess. Please go. Defense rests, case closed.
They said they conceded here.
Good one, Mr. Juan. Hmm. I saw that they left because I saw them coming back as I was finishing my conference call. We got a microwave. Just whenever you're ready. Not going anywhere without you. Right. Yeah, 1 second. All right. Right. It's 1:15. We're back, or actually 1:13. We're back on the record. All right, plaintiffs arrested. We've had their case in chief. Had the benefit of very thoughtful arguments that are a matter of record by both defendants and plaintiffs on the post plaintiffs proofs motions by the defense. We're now ready to begin the defendant's case. Mr. Gamble, is the defendants ready? Okay, you may call your first witness. Mr. France, good afternoon. If you'd be kind enough, our modified witness area is over there, here in the Court of Appeals courtroom. You raise your right hand, please. Do you swear or affirm that the evidence you will give in this matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please be seated. Sir, could you state your first and last names, please?
Certainly. John, John, France, France, like the country.
All right, thank you. And Mr. Gamble will examine, who's going to be doing cross? Mr. Juan and Mr. Dubin will be doing the cross. The way that our schedule works, and I think you were here earlier this morning, but we go about 90 minutes or so, and then we'll take a 15-minute recess and then continue the testimony. I don't know whether you're going to be with us for several days or several hours or what that might be, but I look forward to the benefit of your testimony. If at any time you don't understand a question that I might have or a question of either the lawyers, if you could ask them to restate it. Ms. Heacock, our court reporter, if she's having any trouble hearing you, she'll let us know, I think, at least based on many years of experience working with her. I suspect she will let us know. I don't think I have anything else preliminary. Do you?
No.
Anything else from plaintiffs before we get started? All right, great. And is it doctor or Mr.?
Mr.
Okay, we've had so many doctors,
I
and I was
know.
just on a conference call where one of the individuals was a medical doctor, and then anyway, and then they called me doctor. I said, I am a doctor. I have a doctor of law. But anyway, so you don't have to call me doctor. You don't have to call me anything. Just look forward to your responses and your testimony. Thank you.
Indeed. Thank you.
Thank you, Your Honor. Good afternoon, Mr. France.
Afternoon.
Before we begin your examination, Amy, could you bring up defendants 146? Oh, could we get Amy or the MDAG? Thank you. Your Honor, we wanted to call your attention to a defense, before we examine Mr. France, call your attention to Defense Exhibit 146, which is a letter to the plaintiffs from the legal counsel for the Federal Energy Regulatory Commission. And I had actually been contacted by their legal counsel, and they wanted to be sure that the court was aware of this letter, and we had already submitted it as an exhibit, as one of our exhibits. But there's a letter, it's not addressed to Mr. France, but before we examine him, we wanted to put the court's finger right on it, which is that the counsel for the Federal Energy Regulatory Commission, they want to be sure that as Mr. France provides testimony, sworn testimony, that he does not speak. Well, there's two things. First, that he does not speak on behalf of the Federal Energy Regulatory Commission. So, Mr. France, do you speak on behalf of the Federal Energy Regulatory Commission?
I do not, sir.
Okay, so
What's the date of the letter? I just don't see it.
it's actually not dated at the top. It's down at the bottom. I believe it's June. It's only in the signature. I believe it's June 2025. It was early last summer.
Good.
Or mid last summer. Yep, June 12th, 2025. So Mr. Francis confirmed he's not here to speak on behalf of the Federal Energy Regulatory Commission. And the other matter that counsel for the Federal Energy Regulatory Commission wanted to be sure is that Mr. Francis doesn't speak about deliberative process, matters covered by the deliberative process privilege of Federal Energy Regulatory Commission staff. And so I'm just affirming on the record, I don't intend to ask him questions seeking information that would be protected by that privilege. In fact, Mr. France, to your understanding, did you have deliberative conversations with members of Federal Energy Regulatory Commission staff members?
To my understanding, no, I did not.
Okay, I mean, you contacted members of FERC's staff to learn about the history of the dam as part of your work in this case, is that right?
Yes, we interviewed some of their staff who had been involved on these projects, on the Boyce Energy projects, Boyce Hydro projects over the years in fact finding, but we did not. They were not part of any of our deliberations in our work. We did not have any deliberative meetings with them. They were interviews for fact finding.
Okay, and I won't even ask questions for Mr. France, questions about what people from FERC told him unless it's something that's printed in this public report. So,
All right.
okay.
Yeah, I'd like to, just let's, Mr. Juan.
I'd like to understand this. We understood this letter directed to us, prohibited us from talking about the deliberative process of the IFT. Not deliberative process between Mr. France and FERC, but the deliberative process of IFT. And so to talk about looking down behind the scenes to come up with the report was off limits. That's how we understood this.
Did you depose Mr. France?
We did not depose Mr. France.
All right. Anything else you'd like to say?
No.
Anything else, Mr. Dubin?
No.
All right. I will, as I have in each of the witnesses who've been before the court, I will attempt to be attentive and I will look if a lawyer for either side believes something inappropriate is happening, I'll look to them to object and then I'll ask for responses from the other side's lawyer and then I'll attempt to rule. And if we need to, we haven't had to do this in the case yet, but I'm certainly comfortable excusing a witness temporarily from a courtroom while the lawyers and I talk about matters. I don't anticipate that, but I've done it scores upon scores of times in my service as a judge previously. And does that sound like a satisfactory sort of model so far?
Just fine, Your Honor. Yep.
Good for us. Yes, sir.
Okay. All right. Thank you.
Amy, you can put that down. Thank you. Okay, Mr. France, on to your testimony. Amy, could you bring up defendants 106? And let's go down to page 481. Try and make this a little bit bigger for Mr. France. In fact,
You said 49,
481.
81?
No, leave the top, leave it the E106. Fine. Thank you. All right, Mr. France, is this the resume that was attached to the IFT report?
Yes, it is.
And I mean, it's been a few years, so it might be a little out of date. Is that right?
It is, 4 or 5 years old now, but
Okay. I think it'll serve our purposes here. So, Mr. France, could you tell us about your education?
certainly. I have a bachelor's degree and master's degree, both of them from Cornell University. Bachelor's degree was awarded in actually, should I say 1973, not 72. But awarded in 1973. I stayed on then to do a master's degree, which I left the university in 1975 with my thesis not quite complete, which I would not advise anybody to do because it took me a little longer to get it done than I'd like, but it did get completed, and I was awarded a master's degree in January 1976. My undergraduate degree was a Bachelor of Science in Engineering. It was in the Civil Engineering College at Cornell, but Cornell actually does not ascribe civil engineering to that degree. They believe an engineer really needs to be educated for at least 5 years to have that ascribed to it. But I stayed on for 2 years to do a research thesis master's degree and successfully completed that, and it was awarded in 1976. My concentration in the master's degree was in geotechnical engineering.
And could you explain to us what those credential letters are next to your name at the top there?
Certainly. The PE is professional engineer, and I am registered as a professional engineer, civil engineer in Colorado, Massachusetts, North Carolina, and Oklahoma. The DGE and the DWRE, I think the court has already heard some related testimony from Dr. Marr. That at the time was diplomat, geotechnical engineer, and diplomate water resources engineer that have subsequently been changed by the ASCE to board certified geotechnical engineer, board certified water resources engineer. Those are designations by the institutes of the Association, or the American Society of Civil Engineers, for people with extensive experience in those particular areas of engineering practice.
And Amy, could you magnify the areas of expertise for us? Mr. France, could you explain to us what the dam safety area of expertise is?
Certainly. I've been practicing as a consultant and consulting engineer in private practice for over 50 years now, starting in 1975. And throughout my career, I have been involved in dam engineering and dam safety, starting most extensively in the late 1970s, and then in particular since about the mid 1980s. Almost all of my practice has been in dam engineering and dam safety. And dam safety involves dam inspections, evaluations of dams, studies to improve dam safety if a dam is found to not meet the requirements of a regulatory program or any other way judged to need improvement. I've also done some work reviewing dam safety programs over the years. And then more recently, the last 20 years or so, a lot of my work has been involved in consulting review boards or senior review boards for various agencies, the Bureau of Reclamation, the Corps of Engineers, the TVA, and dam owners like BC Hydro and Brookfield Energy.
And what about dam and levee engineering? Could you explain that to us, please?
It's a broad category of really anything to do with engineering for dam structures or levee structures. Being a geotechnical engineer, a lot of my work focuses on the earth structures, the embankments, embankment dams, and levee embankments. But I have also done projects related to concrete dams and concrete structures like spillways that are auxiliary to concrete dams. So it's a very broad category of any of the engineering sort of related to dams and levees, including being a project manager on multidiscipline projects that might also involve engineers who are doing hydrologic, hydraulic work, as well as structural work and geotechnical work.
Could we hold on a second? Elizabeth, could you come here a moment? Please continue.
And what about civil and geotechnical engineering?
Again, a broad term, civil engineering, of course, covers all of the areas of civil structures. My focus certainly has been dams and levees. And then geotechnical engineering is my concentration. Civil engineering includes a number of disciplines: structural engineering, hydraulic engineering, transportation engineering, and my focus in civil engineering has certainly been geotechnical.
What about, what's your involvement in water resources?
I included water resources on that list because the projects I'm involved in, dams and levees, are water resources projects. They're projects for purposes of storing water for use, irrigation, water supply, or structures that are used for flood management. We used to call it flood control. I've tried to expunge that from my vernacular because I don't think we can control floods. The best we can do is manage them. But flood management type of structures, so the broad category of water resources.
And then finally, seepage and slope stability analysis. Could you explain that to us, please?
Certainly. I chose to list that there because those have been two of the particular focuses of my work. I actually teach courses for the Association of State Dam Safety Officials, ASDSO, teach courses, 1 week long courses on seepage and slope stability that are taught annually or every other year to members of ASDSO and others on seepage as it relates to embankment dams and slope stability as it relates to embankment dams.
And you mentioned the ASDSO. Is that the Association of State Dam Safety Officials?
Yes, it is.
And is that a organization you belong to?
It is.
Do you also belong to the U.S. Society on Dams?
Yes.
What does the U.S. Society on Dams do?
The U.S. Society on Dams is, there's an organization called the International Commission on Large Dams, ICOLD, ICOLD. And ICOLD is an international organization of member states in the throughout the world. And I think they're either at or approaching 100 different countries now that have member groups that belong to ICOLD practicing in dams. And the U.S. Society on Dams is the U.S. member of ICOLD. So USSD is a professional organization of people who are involved in dam practice, mostly dam engineering, but also some of the environmental practice related to dams and some of the softer sciences related to dams. And they have this affiliation to the international community to help both communicate to other members in the world what U.S. practice is doing and to learn from other countries in the world what those are doing and bring it into U.S. practice. And USSD is that American representative. And it is part of its role is education and information sharing. It operates in large part through technical, volunteer technical committees that put together bulletins on different aspects of dams and dam engineering. And at USSD, I served 6 years as a member of the board of directors and 1 year as the vice president of the organization, and have been involved since, I believe, the late 1980s.
And of the professional associations listed here on your resume, I believe the Association of State Dam Safety Officials issues like guidance documents to its members about dam safety practices. Am I understanding that correctly?
I think the ASDSO's role has been more in training rather than guidance documents. USSD actually has been more issuing guidance documents and bulletins. ASDSO has been had more of a focus on training, in particular, training state dam safety officials. Its history is interesting. It was formed in the late 1980s. And just a little bit of, if I may, of history of dam safety practice in the United States. In the 1970s, there were a whole series of dam failures, of serious dam failures. Two of the most noted ones being Teton Dam, which failed in 1976. and was the first, to my knowledge, the first major failure or first failure of a major federal dam. So it took a lot, got a lot of attention because of that, failed during its initial filling. And it was followed less than a year later by failure of a smaller dam in Georgia called Toccoa Falls that unfortunately resulted in a number of fatalities at a Bible school downstream of the dam, failed in the middle of the night, and a number of these students and faculty were unfortunately lost their lives. At that time, the President of the United States happened to be Jimmy Carter. I think his wife Rosalind actually traveled to that site within hours or within a day after the site and got a lot of attention. And there had been some effort earlier in the 70s to try to get some national action on dam safety. There really hadn't been much national attention to dam safety before that. And there'd been some effort by Congress to start moving in that direction. And after Teton and Kelly Barnes, President Carter signed an executive order, and things really started to happen. And dam safety got a lot of attention in the United States. And we found that at that time, there were a lot of states that didn't even have dam safety programs in the country. There were others that did. But we started to try to improve that. And one of the things to improve that is some of the officials in states that had programs that were relatively active in the mid-1980s got together and they said, you know, we really need to get together as a group and we need to try to help improve this practice across the country. And they formed the Association of State Dam Safety Officials. And one of its purposes was to improve state dam safety practice. And in my estimation, they have done a very good job of that. We now have state dam safety programs in all the states. And some are stronger than others, but even the ones that aren't as strong are getting stronger. And a big role that ASDSO promotes is helping train the state officials and also training other people who are involved in dam safety practice in the U.S. in good practice in dam safety. So I see training more than guidelines as the things that ASDSO does.
As far as you know, does the ASDSO train its members that anytime a dam lacks spillway capacity, that means the impoundment must immediately be drawn down?
I have never seen that as a suggestion.
What about for the U.S. Society on Dams? I think you mentioned that's the organization that does issue guidance documents. Am I remembering correctly?
You are remembering correctly.
Did they, as far as you are aware, do they issue guidance to their members directing that if a dam lacks spillway capacity, the impoundment must immediately be drawn down?
As far as I recall, I have never seen that guidance in a USSD document.
Going back to your resume, if we can highlight the spillway incident forensic. See that? Thank you. Mr. France, could you tell us about your involvement in this matter in Oroville?
Certainly, it's an interesting story. I suspect many of you may remember, because this story got national attention when it occurred. In February 2017, there was a failure of one of the structural concrete slabs in the service spillway at Oroville Dam. And Oroville Dam is the tallest dam in the United States. It's an embankment dam. The impounding structure is actually an earth embankment. But the problem that they had was with this concrete spillway that because they lost this concrete slab section on the spillway, there was great concern about whether they could continue to run water down the concrete spillway without further damage and potentially even having erosion progress back up to the reservoir and release the reservoir and cause downstream flooding, as well as they were concerned about there were some electrical power lines coming out of the powerhouse on either side of that spillway. And if erosion extended too much, it may well compromise those power lines, and then they wouldn't be able to generate power out of the powerhouse. For those various reasons, they chose to try to limit the flow out of that spillway. When they did that, they still had a lot more water coming into the reservoir, and water went over an emergency spillway that had never operated before. And suddenly they got erosion of the earth hillside downstream of that spillway. And they were concerned that they were going to have to, that spillway might fail. And as a result, they evacuated 180,000 people downstream of the dam. Fortunately, it did not fail. There were no lives lost. But it turned into over $1 billion repair project for the California Department of Water Resources. So a major incident. It was, in addition to being regulated by California, it was regulated by the Federal Energy Regulatory Commission, the FERC. And FERC sent a letter to the owner, California Department of Water Resources, and said, you need to convene a team to do an independent forensic investigation of what happened here and what we can learn from what happened here. And they gave some requirements for what that team needed to be. Coincidentally, in 2017, I had just made a decision to leave employment with my prior firm and to do some independent consulting, but to go into semi-retirement. This happened in February 2017, and California turned to ASDSO and USSD to ask them to put this team together. And some of my good friends at those two organizations called me and asked me, would you be the leader of this forensic investigation team? And I said, I just decided to semi-retire. I'm not sure this is something I want to get into. And this goes on for about a month before they finally twisted my arm enough. And these are good friends. I felt I couldn't say no to them, so I agreed to do it. I agreed to lead that investigation, help them assemble a 6-member team, myself and 5 others. And I'm very happy I did in the end, because it was a very rewarding professional experience. We spent about 9 months together investigating that failure, issuing a report that I feel in general was very well received by the profession. I think has made some changes in the way the profession does its business. We learned some things from Oroville, and was a very one of the most rewarding things I think I've done in my 50 years.
Speaking of rewards, did the team actually win an award?
Yes, ASDSO chose to award the team the President's Award that year for the work that we did.
Was that compensated?
Pardon me?
Were you compensated for your time on that?
For the investigation?
Yes.
Yes, we were. We were
I don't need to know the details. I just
contracted by Department of Water Resources, but we were.
I've
paid
served
for it.
on an advisory panel that was uncompensated.
Thank you for your service.
That's okay. It's not, it was an avocation, not a vocation.
I have done some of those too,
I
but this
suspect
one was
everybody in this
compensated.
room probably has. So, okay.
And
you.
what I think you mentioned that some changes were made because of the report or because of the investigation team's work with the Oroville Dam. What changes are you referring to?
The most significant of the changes I was referring to is one of the things that we concluded from our investigation of Oroville was that the project was built in the 1960s. It was under FERC regulation. And there were evaluations done over the years, in particular after the FERC put into place its. Certainly.
I think it is. I think, Mr. France, you're enunciating so clearly and so well, like so many engineers that I was raised in the household of. If you could move the microphone just a little bit away from you, which is maybe words I have never spoken in 40 years of being a lawyer or a judge. So Thank you.
I will do that. And if it's not far enough away, let me know. I will move it further.
Okay, no, we still need to hear you. I think it's catching the ends of your syllables a couple times.
Okay, thank you.
Thank you.
So one of the things that the FERC put into place this Part 12 process that they have, where every 5 years, the owner of a hydro project is supposed to needs to engage an independent consultant, and the independent consultant needs to be approved by FERC to do what they call a Part 12D inspection. And they call it inspection, little bit of a misnomer from what the regulations were written up to say it should do, because in addition to going out and doing a physical inspection, that inspector is also tasked with reviewing the history of the dam and its condition, analysis that have been done to it, and reaching conclusions about its condition and its suitability for continuing to be in service. And what we found when we did the investigation is that despite those words in the FERC regulations, that really wasn't the practice that was happening. And part of it, I think, was a commercial result that as the hydropower industry had changed, the competition to get this kind of work became too much of a commercial competition with some owners looking for the lowest price organization that would do this work that FERC would approve. And the engineers who got selected to do it got squeezed in their scope of work that they had to do this, and their review of the past investigations, analysis, construction, such was not occurring as thoroughly as it should have. Because one of the things we found with Oroville is the information that indicated the vulnerabilities that led to the spillway failure, that information was all there. People just had not dug it out and looked at it and appreciated it and known it for what it was. So one of the conclusions and one of the recommendations wasn't so much a recommendation in these forensic reports. We put in a section called lessons to be learned from what happened. And one of the lessons to be learned is that simply going out and doing visual inspections is not sufficient in itself, because there can be latent issues from construction, design, performance that are not indicated by walking out and looking at the dam, and what nobody has X-ray eyes, so you can only see what you can see. And that you really needed to be more thoroughly going into that record of the history of the project, and recommended that needed to be incorporated more into practice. And FERC did eventually take that into account, and in 2022, since 2022 has begun starting to do that and requiring that kind of evaluation, but it had not been done prior to that. And although they're not FERC organizations, I think some of the states and some of the other organizations and owners have also started to do that more with their projects. So that was something that it really, how many of them started? We issued that report in late 2017 or early 2018. FERC did not go through its formal process until after 2020. Other owners and states, I don't know exactly when they may have started doing that, but I know some of them have started doing it. Whether they started sooner than 2020 or not, I don't know. But it takes time for practice to change. And 2018 was when we issued the report early, and it's changing slowly over time.
Amy, could you magnify the next one below that called review of dam safety risk? Mr. Francis mentions your involvement in a review of dam safety risk analysis practices. Does that involve potential failure mode analysis?
potential failure mode analysis as well as quantitative risk analysis as being done by the federal agencies that are mentioned there, the Corps of Engineers, Bureau of Reclamation, and the Federal Energy Regulatory Commission.
And what was your work on this team?
This is another one I got myself into by not being able to say no to my friends. Initially resisted doing it, but then agreed. This effort actually came out of the Oroville work because Congress, I believe, principally at the behest of congressional representatives from California, passed a piece of legislation that required the Corps of Engineers to engage a team to complete this review. The Corps asked me if I would lead it, which after some discussion back and forth, I agreed to do. And this was a 5-person team, international team. We had a representative from the Netherlands, a representative from Australia, 3 of us from the United States. We were tasked with looking at what those 3 agencies were doing as far as applying risk analysis to dam safety and providing any recommendations we might have for ways that they could improve what they were doing.
Amy, could you go down 2 pages? And could you magnify starting with instructor seepage analysis on the bottom third or so? Yeah, that block there.
One thing I forgot to say, Mr. France, when we got started with your testimony, if anytime you need to take what we used to call in the Navy and Marine Corps a health and comfort break, just let us know and we'll respect whatever requirements you have within reason.
I appreciate that. I will do that. I think I'm kind of on your 90-minute schedule.
Perfect. Persons of a certain age.
Yes, indeed.
So, Mr. France, I think you mentioned earlier that you did some course instruction. So I just wanted to call attention to just a couple of these. We don't need to go through every line of your resume, but could you just explain to us what, well, actually, you already explained seepage analysis for embankment dams. The next one on that list, what's your work with slope stability analysis for embankment dams? Could you describe that for us?
Yes, that's again an ASDSO course. I'm one of 3 instructors on that. And in that course, we talk about the fundamentals and practicalities of slope stability analysis for embankment dams. And it goes anywhere from how you characterize the strengths of soils, how you actually conduct the stability analysis themselves, which these days are done with computer programs, and stresses really a lot of the importance that computer programs are computer programs. But the thing that's really most important is you need to focus on the inputs to those computer programs, what you know about the cross-section of the dam you're analyzing, what you know about the soil properties of the dam you're analyzing, and to really dig into those. We have some exercises throughout the 3 days of that course where we have some of the students do some things related to the courses, the information we've been teaching, to try to see if we can get some feedback on how well the information is getting through to them. And at the end of the session, actually spend a half a day going through and allowing them to work with one of the computer programs to do some stability analyses for embankment dams.
You mentioned the importance of good inputs into these computer programs. Could you explain that a little bit more, what you mean by that?
Sure. These courses consist of a series of lectures, if you like, or presentations on different topics, interspersed with these exercises and discussions and other things. And one of the ones that I present there is I present a module that's called, I mean, I get the words exactly right, but sort of what's important, what's not important in slope stability analysis. and go through some examples with programs. And the kind of things I look at are there are different properties of soil, some of which I think you've heard of in testimony in this case already. There's the density or the unit weight of the soil. There's the strength. Within a embankment dam, things that are important are what are the different zones, the core, the shells, the filters, the foundation, what's the layering in the foundation, all of those different materials. And collectively that zoning and foundation layering, we call the stratigraphy within the cross section. How are those, what are the materials, how are they distributed? And then for each of those materials, you need to assign some kind of characterization of what is its strength. And then you also, soils are a combination of solids, and between the solids, there are void spaces, and the void spaces can be occupied either completely by water, completely by air, or by some combination of water or air. And depending on that, that affects somewhat the behavior. But one of the more important things is where is the line of saturation that goes through the dam, and where the soil is saturated versus being unsaturated. And then what are the water pressures within those pores? Those are the kind of things that can go in there. What that module demonstrates is that far and away, the two most important things in a stability analysis are the strength and the stratigraphy, the distribution of the materials and the kind of materials and the strength of each of those materials. And then sort of right behind it is the pore water pressures, and what the pore water pressures are that are within the pores of the soil. We look at things like a computer program that you might use, and we find that if you use a credible computer program, it doesn't make any difference. All the credible commercially available programs that are out there right now give you the same answers. And then over the years, there have been different mathematical formulations for doing the calculations in the stability analysis starting back in the 40s, 50s. And most of the modern computer programs that do stability analysis will allow you to use any number of those. And what you find is, in general, that doesn't make very much difference either. The different programs within reasonable degree of geotechnical engineering accuracy give you the same answer. So the program, the method of analysis within the program, not very important. Concentrate on the strength. Number one, the stratigraphy, number two, and the pore water pressures, number three.
And is it, in your experience, is it fair to say that the reliability of the results generated by the program depend entirely on the reliability of the data that's input into the program?
Absolutely. It's the old computer adage, garbage in, garbage out.
And finally, that last line on there, publications and presentations. It says that numerous publications and presentations for various organizations. Do you have any numerical guess on how many things you've published over your 50-year career?
It's in the hundreds. I was not so much recently in the past few years since I've been semi-retired, but for most of my employed working years, I was publishing and presenting papers at ASDSO and USSD on an annual basis at both conferences. USSD, or ASDSO rather, has a publication called the Dam Safety Journal. I published a number of articles in that Dam Safety Journal. Most recently, one on static liquefaction that I published after the work at Edenville.
All right, Mr. France. So you served on an independent forensic team for the Oroville Dam problem. Now let's transition to you explaining to us how you came to be involved in the independent forensic team for the Edenville Dam failure. And so could you just explain to us how you first came into contact with the issue and what your role is?
I can. After the failure at Edenville happened, as was the case after the failure of the spillway at Oroville, FERC issued a letter to the dam owner, Boyce Hydro, directing them to engage a independent forensic team to evaluate the failure and to do the same things that was done at Oroville, to look at it, to try to develop what were the causes, what can we learn from what happened at Edenville. They directed Boyce Hydro to do that. And after they directed Boyce Hydro to do that, my friend Irfan Alvi, who was a member of both of those forensic teams, contacted Lee Muller of Boyce Hydro. And he had some discussions with Lee. And then he contacted me and said, do you have any interest in serving on this team? And I thought a bit about that and decided, okay, I think I will be interested in doing that. And part of the reason I thought I'd be interested in doing that is I, like many people, had seen the video of that failure when it happened. And having had some experience with liquefaction and static liquefaction in the past, I had a suspicion that that might be what it was. And I had some concern that depending on who took on the geotechnical role on that forensic investigation team, we may or may not get to that conclusion. And I decided that it was sort of important that that failure mode be at least part of the thought process when people were looking at it. So I agreed to do it. And Lee and Irfan and I started talking with Mr. Muller. And FERC had identified a number of other disciplines that they wanted covered in this forensic team. So we, Irfan and I, suggested people who would fill those other roles. And we began to have some discussions with Lee Muller about coming under contract to Boyce Hydro to do that work. We decided that if we sort of looked at the situation, we recognized, Boyce Hydro were a little shaky about Boyce Hydro's finances at this point in time. So we were going to be pretty cautious about how we contracted with Boyce Hydro. So in our discussions back and forth, we drafted some draft contracts that we would be willing to work under. And the terms were not easy. Our terms for Boyce Hydro were basically, for us to do this, you need to pay us in advance a certain amount of money. We will work against that amount of money as we do our work. And if we get near the end of that amount of money, we'll ask you to increase it. And anytime we run out of money that you've paid us, we're stopping because we were very concerned. Turned out we were probably wise in doing that because after these discussions went back and forth for a number of weeks, Boyce Hydro ultimately declared bankruptcy. So at that point, it wasn't clear who would pay for a forensic investigation. FERC believed that it was important that a forensic investigation needed to be done. I agree with them on that. And so they decided to step in and to issue contracts and contract with the members of the independent team so that the investigation could proceed. And they engaged us, but the terms of our engagement and our insistence on the term of our engagement is we were being engaged as independent consultants. We were going to do this investigation independently. It was not going to be directed by FERC. They were paying, but we were the ones who were doing the work and we were going to do it independently of them.
And Amy, if you go up one page, this lists the members of the team. You're there listed on the bottom. You're the team leader. Is that right, Mr. France?
That's correct, as well as a geotechnical specialist.
And if we go to the next page, Amy, the other members of the team is Irfan Alvi, Art Miller, Jennifer Williams, Steve Higginbotham. Are these all people you were familiar with
Yes.
before working with them on the IFT? Are these people you were familiar with?
Yes, familiar with Irfan Alvi from working with him on the IFT for Oroville. The others are people who I had worked with previously.
And I believe it states in that top highlighted section that your work issued or began on July 31st, 2020. Is that right?
July 31st, 2020 is when our contracts were issued and we commenced work, yes.
Okay. And then you ultimately issued the report like early May 2022. So almost 2 years that you were working on this?
Yes.
You mentioned, Amy, can you magnify that next highlight? Thanks. You mentioned that one of your conditions on doing this work for the Federal Energy Regulatory Commission was that you would do your work independently. Why was that important to you?
It was important to us that these, the FERC was a party to the project before the failure. So we were going to be asking questions. We were going to be evaluating what they did, possibly presenting some opinions on what they did. And to us, it was very, very important that they not influence any of those opinions, because some of those opinions might not be favorable to the FERC. And we were not working, our belief is we're not working doing this work to serve the FERC. We were doing this work to do a forensic investigation, principally to serve the profession, to try to understand what happened and to try to understand what we can learn from what happened to improve the way the profession does its work.
And you mentioned that you also worked independently, not just of the FERC, but also of Eagle, Boise Hydro, and the Four Lakes Task Force. Is that correct?
Yes, correct.
Did Eagle or Boise Hydro or Four Lakes Task Force direct your work on the IFT?
No.
Did they have the opportunity to review your substantive work before it was completed and offer comment to try and direct its conclusions?
The only review that those parties had, and it's mentioned later here in the report, is that when we were writing our report, there were places within the report where we were reciting factual information as we understood it from reviewing documents and from interviews with persons involved with FERC, Eagle, Boise Hydro, and Four Lakes Task Force. And in some cases, as I think everybody's familiar from the testimony in this case, a very complicated history to this case. And we had some concern of, even as careful as we tried to conduct our interviews and as careful as we tried to conduct our reviews, and there was such a massive amount of information that we might have misunderstood or misinterpreted what we heard. And we wanted that factual information to be as correct as we could. So there were some passages that we sent to these entities and said, did we hear what you said correctly? Did we interpret the documents correctly? Is this consistent with the history of what happened? But none of those sections we sent to them related to opinions, and they in no way, they did not review our opinions before the report was issued and did not in any way influence any of our opinions before the reports were issued.
Amy, could you magnify the next sentence down for us, please? Thank you. Mr. France, it says that the purpose of the investigation was to identify lessons, among other things, was to identify lessons to be learned by the industry. Why did you use the phrase "to be learned"? Was that specific language you intended to use in that way?
It was very deliberate language. We used the same language in Oroville and had the discussion in Oroville, and it carried over to Edenville. Is sometimes you see these things written and people talk about lessons learned. Our discussions that we had during the course of this, and in Oroville the same, is, well, if they're lessons learned, we learned them already. Well, if we'd learned them, this wouldn't have happened. So what this incident and what our work is doing is trying to identify what should we learn from what happened here. So there are lessons to be learned. And it's now up to the industry to take those lessons to be learned and to try to apply them and learn them and improve the practice moving forward.
Amy, could you go down to page 28? And let's work through some of these matters under section 1.4 of the report titled Investigation Methodology. Mr. France, you mentioned that, or the report mentions that the IFT endeavored to complete as thorough an investigation and evaluation as practical. And so let's hit some of those bullet points. That first bullet point, it says a thorough and critical review of initial documents, data review. I mean, just without belaboring the point, how many documents were involved in this review, Mr. France?
I would hazard to say thousands.
And did you gather these documents as widely as you could from as many people as you could?
We gathered them as widely as we could. We did not have a subpoena power. We did not have a power to compel anybody to give us anything. We were reliant on what people would give us. So we asked Boise Hydro, we asked FERC, we asked Eagle, we asked Four Lakes Task Force. We asked as many people as we could to provide us the documents that they had. And I think they were forthcoming. And we got lots of documents from particular Boise Hydro and FERC. We did with FERC have to sign non-disclosure agreements before they would, because their information is subject to the critical infrastructure requirements, critical energy infrastructure requirements. So we had to sign NDAs to get their information, which we did. But beyond that, we recognize that there might be other sources of information out there also. So we tried further reach out. We worked with ASDSO and we established a separate Gmail box that was just owned by the IFT. And with ASDSO's help, we sent press releases and we issued other public calls and we said, anybody who has any information that they think might be relevant to this investigation, please contact us at this email, let us know what you have, and we'll reach out to you. And we did get some responses to that email. Some of them we looked at and we thought that looks like it might be information that would be useful. We did actually contact them. We interviewed them. We got further, more detailed information from them. So we, without a subpoena power, without other ability to compel documents being produced to us, we tried as best we could to cast a broad net and get information in that might be relevant to our investigation.
Did the documents that you were able to acquire include all past inspection reports while the dam was under FERC jurisdiction?
I believe so.
And Amy, you can drop that magnification. Could you magnify the next bullet point? Oh, no, not that one, the next one down. Sorry, that starts with a visit to the site. So did members of the IFT team actually go and visit the site of the dam failure?
Yes, initially 2 members of our team, Jennifer Williams and Dr. Art Miller, did visit the site in September 2020. This occurred, as you can tell from the dates, occurred in the midst of COVID and before we had COVID vaccines. So some of us on the independent forensic team did not feel comfortable traveling at that point in time, myself being one. I was 68 going on 69 at that time and was in what they were calling the more vulnerable group and didn't feel comfortable traveling. Dr. Miller actually is older than I, but he felt comfortable driving from Pennsylvania to the site, so he did visit the site. And Jen Williams, who's a bit younger, was comfortable traveling, and she also traveled to the site. So the two of them made an initial site visit in September to see the site, to talk with some of the entities there, to look at some of the records that Boyce Hydro had on site in its facilities, and to conduct that initial site visit on behalf of the IFT.
And did members of the IFT go back to the site a little bit later?
One member of the IFT, Jen Williams, accompanied by a staff member from AECOM, Harry Donahue, did go back to,
France,
yes,
you said Ms. Williams was accompanied by a staff member from, and I just didn't catch the
AECOM.
what is that?
Could you spell it for us?
Yes, it is AECOM, all capitals. It's a consulting engineering firm.
Okay.
And Miss Williams is an employee of AECOM, and it was the last firm I worked for before I went out on my own as an independent consultant.
Amy, could you go to the next page and magnify the first black bullet point, starting with meetings and interviews? See that first black one? Yep, meetings and interviews. There you go. Thank you. Did the work the IFT did to gather information include interviewing individuals, Mr. France?
It did.
What sort of interviews were conducted and with who?
As we noted here, we interviewed more than 25 different people. All the interviews were conducted virtually, again, COVID times. Some of the interviews, some of the individuals were interviewed more than once. Most of them were fairly extensive and lasted more than an hour. Most of them were attended by all of the IFT members. There may have been some where one or more of the IFT members could not attend. And when we did that, we tried to be very careful that the topic of that interview and the person being interviewed was not key to that person's discipline and role in the IFT. But most of them, the lion's share of them, all the IFT members attended. They were conducted, they were not recorded. They were done through Teams, through Microsoft Teams. They were not recorded. They were intended to be confidential. And actually, we worked out a written statement that I read at the beginning of each interview of what the ground rules of the interview were. And the ground rules of the interview, roughly, paraphrasing and remembering now, were that these were intended to be confidential. They were not being recorded. We may be taking notes, but after we completed our work and issued our report, we were going to destroy our notes. We were not going to keep them. We were not going to attribute anything we wrote in our report to any particular individual who we spoke with without their prior permission, that we could use their name in attributing that to them in the report. We were doing that because we wanted it to be confidential. We wanted it to be open. We wanted them to feel as free as they could to speak their mind and to say what they wanted to say and not hold back. So those were the ground rules that we set. To best of my knowledge, we stuck by those ground rules, and that's the way we did all of the interviews.
Amy, could you go down to
Let me ask a question. Did you have business rules, business practice rules? Did you develop rules for how the internal business practices of the IFT were going to take place?
We did not develop formal rules.
Thank you.
If you magnify that middle highlight there, yep, the one you're hovering over, thank you. Mr. France, it mentions over 50 IFT working sessions. Could you explain what those sessions were like and who was involved?
Certainly. So this is over almost 2 years, 22 months or so of work that we did. We had these 50 working sessions, and they were, again, conducted using Microsoft Teams as virtual meetings. And as you can imagine, as the 6 IFT members are working through all this massive information, we're reading this information, and we're having these interviews and we're hearing what people are telling us. We're all maybe reading and hearing different things and focusing on different things that we're seeing and hearing. And it was important that we then get together as a group and we work that out. We talk about, well, what did we hear and what do we think is important with that? And sometimes that would lead to another interview we need to do or a re-interview with that person that we need to have. And as we went further along and we started doing things like our hydrologic model of the flow into the lake, there were things going on there that we wanted to talk about as a group and understand what Dr. Miller and Hayden Lasasso, who was supporting Dr. Miller, what they were doing in their model, questions they had, and a number of different things that we needed to talk about. We took that video that was a vital piece of evidence in this work. We took that video and we looked at it collectively together. We stopped it. We looked at it frame by frame. We talked about what we saw. As we started to work through, well, what do we think physically happened there? We had, as we explained in the report, 3 or 4 different possibilities that we think could have happened. Mostly Jen and I would present to that team. This is what we're thinking geotechnically is going on there. This is why we're thinking it, and get the input from the other teams. Does this make sense? Is this logical? Do you agree? Because in the end of the day, when we wrote this report, it's going out under all of our names. We need to all agree with what's in that report. So these working sessions were to work out all of those things about our opinions, and we might come in with different opinions and thrash them back and forth. And the purpose is get to a place where we agree what we're going to say and what the report's going to say.
I have another question. When you were in the beginning stages of the work, was there any discussion or was there any agreement on, if there were not agreement, how you would handle non-unanimous conclusions?
I don't recall whether we had detailed discussion on that. My own approach had that developed of what we would have done. And if there really was someone who could not agree to what the rest of the group thought and what we wanted to write in the report, I certainly would have had no objection to that person having a minority expression of opinion in the report.
But there wasn't a formal policy adopted by the task force.
There was not,
Okay.
but with that group of people, if anybody didn't agree, I think they would have raised the same question, and that's what we would have done.
Thank you.
So during these working sessions, did anyone from FERC or Eagle or Four Lakes Task Force or Spicer Group, Boyce Hydro participate in any of those working sessions?
No, these
That-
were all internal IFT working sessions.
And
IFT and some of the staff that were supporting our work, Harry Donahue, Hayden Lasasso, some of the others that are listed.
And did all of the people participating in these working sessions agree all the time on all topics?
No,
And, and, as the IFT continued to gather information over time, would people change their views over time based on additional information that was obtained?
yes,
And so it could be, for example, that if you spoke to someone at the beginning of this process, they might have expressed some view or another, but by the end of the process, their view might have changed because they learned new information. Is that fair to say?
Yes, it is.
I mean, that's basically the deliberative process, isn't it?
I believe it is.
And when it came time to write the final report, did any members of the IFT insist on including a minority expression of disagreement in the way that you just suggested?
No.
Did all the members of the IFT team ultimately agree on the final product that was issued to the public?
To my knowledge, yes, we all did. And the process of finalizing that report, as was the case for Oroville, was a painstaking process. Some of these working sessions that we're talking about would be working sessions where we had draft sections of the report. We were on teams and we were going page by page, paragraph by paragraph through that report with everybody on the line and talking about, well, I don't like that word and having debates back and forth on what the right word ought to be. And I will say to probably to different degrees of scrutiny, because there are parts of the report. There's the executive summary, which our envision, which we saw as different audiences. There was the executive summary, which we saw as a broader audience, including the public and non-technical people. There was the main report itself, which some of the general public may have some interest in also, but is getting more deeply into the technical stuff and more of the technical people in there. And then there are the appendices, which get even more into the technical detail. And our detail of critical review, most important for that executive summary, we saw that as being very important. We wanted to look at all of those words very, very carefully. The report being next, and then the appendices were written by different specialists who were working on those parts of the work. And all of us read all of that. I read every word in that report, but would be less critical in our review and input to the words in those appendices than we would have been in the earlier parts of the report.
Are you saying that the appendices are less accurate or have inaccurate information in them?
No, just less debate and picking over particular words and perhaps grammatical style and those sort of issues than the earlier parts.
So what you're saying is you put more focus on the parts that you thought would be read most widely by the general public. Is
Correct.
Okay. We're going to look at a sentence that spans 2 different pages. So Amy, there at the bottom, if we could magnify that, make it, oh yeah, perfect. Yeah, let's bring up that sentence. So it says, Mr. France, that evaluations of judgments, decisions, actions, and inactions for the various stages of the project considered the states of practice applicable to the various time periods involved. What do you mean by the states of practice applicable to the various time periods involved?
Well, one of the things that our teams talked about, both the Oroville team and then this team talked about also, is that it is very easy after an event like this happens to look at it and look back at it and be very critical of what people may have done before in light of the fact of what happened. Something that is called hindsight bias, that this has happened and you look back and now, oh yeah, I see, they should have done this, they should have done that. And we wanted to try to be as careful as we could not to inject that hindsight bias into our work, but to look at when we were talking about what people might have done when they were doing construction in the 1920s, we thought of in light of what the technology and the knowledge were in the 1920s. The 1920s, what's now geotechnical engineering, what at the time and for decades was called soil mechanics, was just being created. Prior to 1920, it didn't exist as a science or even a thought of anybody in the sciences or engineering. Carl Terzaghi was just beginning to develop it as a concept, wrote the first book on it in the late 1920s after these dams were built. So as a science, it didn't, as an engineering practice, it didn't exist. And so in a similar way, as you look at how people were doing analysis, how they were interpreting analysis, how they were doing inspections, we believed you needed to look at it and consider it in light of what was the common practice at that time, not what the common practice in 2020, but what was the common practice in 1980 or 1999 or 2010.
And could you tell us a little bit about the concept of dam safety risk and how it's evolved over the years?
I can. If we go back 40 years ago, very few, if anybody in this profession, were talking about dam safety risk. It just hardly as a concept, it didn't exist. Interestingly, it was in some of the federal legislation and federal guidelines in the 1970s that we should start to consider risk in dams and dam safety. But as a practice, it hadn't happened. People weren't doing it. The profession wasn't doing it. It was in the 1990s, the late 1990s. The Bureau of Reclamation started to apply the concepts of risk analysis to dam safety. And they have been applying it ever since. Right in the early 2000s, the FERC first began to require potential failure mode analyses. Prior to that, they had never even required the process of potential failure mode analysis. In the early 2000s, the Corps of Engineers started to look at applying risk to dam safety. That was dramatically accelerated after the failures during Hurricanes Katrina and Rita in 2005.
It was dramatically what, sorry?
Pardon?
Did you say dramatically accelerated?
Yes.
Thank you.
Because of the tension on the Corps of Engineers after Katrina and Rita and the damage that happened from them, they got a real push, and they actually shortly after that formed what they call the Risk Management Center to focus on dam safety risk and levee risk in the Corps of Engineers, and began to dramatically increase what they were doing with that. FERC thought further about bringing quantitative risk into their program, started thinking about that in the early 2010s. And then in 2016, they actually issued draft guidelines for doing risk-informed decision management. TVA along the way in that 2010s period began to adopt risk. In the non-federal sector, and 90% of the dams in the country are non-federal, in the non-federal sector, it's happened even more slowly. So 40 years ago, we wouldn't even been talking about risk and dam safety. The conversation has increased where now it is, it's something we regularly talk about. And I think it's good that it's something I think it's improved the way we do dam safety, but it's been a process over more than 30 years.
So you mentioned earlier the concept or the common bias called hindsight bias. Why is it so important to protect against that bias in forensic investigations of dam failures?
In my opinion, it's important because you otherwise can too harshly judge people's actions in light of what ultimately happened versus what was something that would have been common to do at the time that they did what they did.
Amy, let's go to page 6. Could you magnify? Yes, that one. Thank you. So This is a section giving an overview of factors contributing to the Edenville Dam failure. And this first highlighted sentence mentions contributing factors combined and aligned to result in the failure primarily reflects, and there's two things here, primarily reflects both deficiencies in the construction of the dam and deficiencies in subsequent industry practices during the history of the project. So my question is about deficiencies in the construction of the dam. And my first question is, did you in your review identify any evidence that a state agency oversaw or approved the original construction of the Edenville Dam?
No, I did not, and we did not.
And when you talk about deficiencies in the construction in this sentence, are you referring to the type of construction deficiencies that you can just see simply by looking at a dam's embankment?
Well, in the case of Edenville Dam, the principal deficiency in construction was the loose sands that existed with this embankment, within this embankment, that ultimately experienced static liquefaction and led to the flow slide embankment failure that we saw. And that is not something that one can see by a physical inspection, walking the site and looking at the structure. You can't look at that structure and see there are loose sands in there.
And you mentioned earlier that the development of dam safety as an industry has really been relatively recently. Is it, in your experience, is it common for dams built prior to modern dam safety practices in 1924 to lack sufficient spillway capacity under modern standards?
It is certainly not unusual.
Why is that? Could you help us understand?
I think it's scientific knowledge. I think it's, what engineers thought in those times. In the early days of dam construction, prior to 1900, early 1900s, there were not a tremendous amount of stream flow volume records available to predict large inflows that might happen. So engineers were sort of left with, well, what's the best estimate we can make of how big this spillway ought to be? And certainly this whole idea of probable maximum flood, that didn't exist until the 1970s. It was part of this dam safety stuff that happened after Teton and Kelly Barnes, as we came up with hydrometeorological reports that established probable maximum floods. I think there may have been some publications around and some references that talked about extreme floods and provided some guidance for extreme floods, but don't know that it was widely disseminated. And there just, I think, wasn't the scientific knowledge.
And so essentially the dams are built, in this case, the Edenville Dam, 50 years before the concept of probable maximum flood even existed.
Relative to probable maximum flood, that's correct.
And were you surprised to learn that the Edenville Dam lacked sufficient spillway capacity?
No.
It's a common problem in your experience?
Across the United States, it is probably the most prevalent problem with dams across the United States is insufficient spillway capacity.
Is it your understanding that in all these dams in the United States that lack sufficient spillway capacity, that the impoundments have been permanently drawn down until that capacity can be added?
That's not my understanding.
The second thing you mentioned in that sentence is subsequent industry practices during the history of the project. Is it that there were practices that were common at the time in history that are recognized now with the benefit of hindsight that were not that great and that need to be changed. I mean, is that one of the purposes of your investigation in this report?
That's one of the purposes, yeah.
To this next highlight, I'll give you a second with it, but it mentions that like the last two sentences or so, starting in the middle, says all of the parties associated with the dams can be seen as having been acting rationally relative to their respective incentives, but collectively they were operating within a system that had conflicting interests and goals, resulting in a system having non-cooperative relationships. Is one of the examples of these conflicting interests the interest of property owners around a lake or an impoundment versus the interest of the owner of the impoundment and the dam creating it?
In my opinion, yes, it is.
Amy, can we go to page 12?
12, I think.
Yes.
I should let you answer. Just trying to help.
Just trying to help.
Well, thank you, Mr. Juan. It's good of you to remember.
Page 12 of the summary, it says that some of the more significant interactions that contributed to the unfortunate May 2020 dam failures were, you mentioned FERC, but then we highlight the counties and the lakefront residents. Could you speak to us a little bit about the interactions in that highlighted bullet and basically what happened there?
Yes, let me read it for a moment. Yes, and this again, in my view, and I believe in the view of the IFT, is not unfortunately not an uncommon thing across the country. We have over 90,000 dams across the United States, and quite a number of them are smaller dams. Most of them are smaller dams, and in the instance of Edenville, this was a hydropower dam, and the dams that Boyce owned were small hydropower dams. The small hydropower dams built many decades ago. The owner of those dams, his source of income is selling the hydropower, and there's a fixed amount of money he gets. I guess it varies from year to year, depending on how much demand there is for electricity, but he's got money coming in from selling his electricity that he's generating. There are other examples across the country of other types of dams, irrigation dams, for example, where those irrigation companies get the water and then it's used for the farmers, and the farmers make money off the crops, and there's money. So there's money coming from those dams, but unfortunately, what happens is in many instances, as I believe is the case here, the income is not sufficient to support the improvements to the infrastructure that are needed. In this case, the enlargement of the spillway. At the same time, there may be other entities like lakefront residents and counties are benefiting somewhat from property taxes that they collect from the property values of the owners, and the property values are going up because they're sitting on the lakefront. And they also, in this case, there's recreation going on in the counties, and other governments may be benefiting from that. The owners of the lakefront properties have the benefit of that lakefront property value. They have recreation benefits back to other people who can recreate on the lake who don't live there. So you've got this group of people that are benefiting, and similar things may happen in other lakes. They're benefiting, but the burden of maintaining the dam and doing anything needed to comply with dam safety rules falls on the owners. And unfortunately, I think in many cases, as in here, it doesn't balance. The owners aren't getting enough money from their project to pay for what needs to be done. And it's just, to me, looking from the outside, and our team members agreed, it seems a bit of an imbalance. There's benefit going to some folks who aren't having to contribute to pay for it, where this owner is not getting enough money to do what needs to be done. In this case, it's to me particularly sad in this case that the folks here had actually recognized that, and they were on the way to the solution with the Four Lakes Task Force, trying to buy the dams and setting up a structure so that they could actually develop money from those other parties who were benefiting, could actually do the work that needed to be done to improve the safety of the dams, and just hadn't gotten there before we had this storm that led to what happened. So that's what we were trying to say in this paragraph.
Amy, could we go to 31? Could you please magnify, no, not that part, but the part beneath it with the blue? All of that. Yes, please. Thank you. Oh. Mr. France, this notes that all four Boyce Hydro dams, so obviously including the Edenville Dam, had a high hazard classification. But then it notes in orange that the hazard classification does not identify the physical condition or potential for failure of the dam. Could you help us understand how it is that a high hazard dam, if it's classified as high hazard, doesn't necessarily have anything to do with whether it will fail or what its condition is?
Surely. The term high hazard classification, in my view, is like one of the banes of our existence in dam safety practice. It came out of that period in the late 70s, early 80s, when we're starting to develop guidelines, federal guidelines in dam safety, and there were groups of very well-intentioned people working on doing that. They're trying to get things done very quickly, and they came up with this idea of hazard classification: high, medium, low, and it's kind of an albatross to all of us who practice dam safety. Because of high hazard classification, and I don't know how many times, almost every time I do it, when I'm saying high hazard classification, I immediately qualify it with that does not mean the dam is at high risk of failure. It simply means that if it were to fail for any reason, there's a likelihood that there are going to be fatalities. It's just a bad term that was selected. We're saddled with it. It's been there for I guess, almost 50 years now. Other entities have improved their terminology. The Canadians, for example, use consequence category rather than hazard classification. And it's a much better, more descriptive term for what we're talking about, because we're talking about a high consequence dam. And the high consequence being that if it were to fail, people might die, but it has nothing to do with the physical condition and likelihood of the failure, just simply the what if, what would happen.
Amy, could you go to 352, page 352? Could you just magnify the big paragraph in the middle? Yep, just that. Thank you.
Oh, hold on.
Yep.
Go ahead.
Mr. France, this mentions in the orange sentence that the use of the Edenville Dam to help manage downstream flooding had been considered at various times, but the primary purpose of the dam was to generate power, which has a different operating procedure than those for flood management facilities. Could you educate us about the difference between a hydropower dam like the Edenville Dam and flood management facilities and their different roles when it comes to managing flooding?
I can try. The most common approach to flood management dams are basically what you want to do is you're trying to manage against larger floods. And one of the ways to manage against larger floods is to with a dam, create a big bucket so that when a large storm with a lot of water happens, the water from that storm can flow into the bucket, and the bucket holds it temporarily. And then the release facilities from the dam can let it out slowly so that you don't flood the stream downstream. You don't flood the stream out of its banks. You don't do damage. The best examples of this, and I don't know if you have many of them in Michigan or not, but around Colorado, we have 3 of them. We have Cherry Creek Reservoir, Chatfield Reservoir, and Bear Creek Reservoir. And the very clear and obvious thing that you see with those reservoirs when you go see them, you got a really, really big dam and a little pool. There's just this little pool down near the bottom of the dam. The dam is way up tens of feet higher than that pool. And that pool is the bucket. That empty pool is the bucket. And that's the one where the volume of that bucket is significant relative to the volume of the storm that could come in. So if you've got a storm of a certain volume coming in, 100,000 acre feet, maybe that bucket is 40,000 acre feet out of that 100,000. So when that storm comes in, that 40,000 is captured there. The other 60 goes past through the spillway, but then that 40 is metered out slowly over time after the flood passes. And that's the way a flood management dam works. Hydropower dams, on the other hand, are principally designed to want to keep that water up as high as you can so that you can generate power, because the higher the pool is in the dam, the higher the head is on the hydropower units, the more power you can generate. And typically, they don't have a lot of storage relative to a big flood, excess storage relative to the big flood. And that's what you have at Edenville. And the Corps of Engineers looked at that, as is noted in here, and others have looked at it and concluded something I think consistent with what we concluded when we looked at it, is even if you lowered the water down to the top of the spillways, or as low as you could, which you can't quite get to the top of the concrete spillway, but lower it down as far as you could, the bucket is still not very big compared to a significant storm. During that storm, early in the storm, that bucket will fill up and the whole rest of the storm will go out through the spillways.
And so that language that's highlighted in purple, where it mentions reports to the state of Michigan House of Representatives, and then reports by the U.S. Army Corps of Engineers, when it says that the Edenville dams, that the storage provided by the Edenville Dam was found to be inadequate to effectively manage downstream flooding, is it basically saying that the bucket behind the Edenville Dam was just too small to really effectively manage flooding?
Exactly. The bucket isn't big enough.
So to our lay, like my lay ears, I hear like billions and billions of gallons of water that can be held in Wixom Lake. That seems to me like a lot, but in the dam safety industry, is it that much? I mean,
Well, it's all relative, and it's relative to every site. And the billions might seem big, but if the flood is going to put in multi-billions, the billion might not be so big anymore.
and so when the U.S. Army Corps of Engineers, it says in the end of that purple highlight, investigated the flood hazard reduction potential and found it to be negligible. Do you agree with that, Mr. France?
Based on the work that we did with the IFT, I agree.
And then you alluded to it previously, but it's kind of hard to see, but it's the final sentence. It's highlighted in light green. It says these conclusions were confirmed by the IFT's analysis. Oops. Oh. Sorry, I know you're trying to be helpful.
Amy's going to make it easier.
There we go. The conclusions were confirmed. Oh, thank you. By the hydraulic analysis, which showed that pre-lowering of Wixom Lake before the event would have had very little effect on the ultimate lake level during the storm. So let's talk about the analysis that went into reaching that conclusion. Um, could you explain to us what the hydrologic and hydraulic, well, actually, you don't mention a model there. So did the IFT develop a hydrologic and hydraulic model to analyze this issue?
Yes, we did.
Amy, could you take us to 79?
Let's pause. Mr. Juan, did you want to?
Being in an area now, Your Honor, where person being qualified witness and asked the court to accept as an expert, which I'm not, those qualifications not going to be. He's getting into areas right
Okay,
now.
that's fine.
That may not be his own work product, and so I think that that's not.
All right. Do you want to talk about it now before the recess, or do you want to talk about it?
I'll wait till the next question, and then when there's a question on the floor, then I can make a specific objection to the question.
Okay.
Okay.
That's up to the court. Maybe
No,
I'll-
that's fine.
keep going.
No, listen, they got experienced, good litigators. I'm gonna, let you call the balls and strikes. I'll call the balls and strikes. You step up to the plate. So, okay, it's 10 minutes before 3, 2:51. Let's recess until 10 minutes after, 10 minutes after 3, and we will see where that takes us next. Satisfactory to the defense,
Yes.
people, plaintiffs? All right, we're in recess till 10 after. Thank you. Elizabeth? Oh. Ah. Elizabeth? Jesus. Mr. France, would you like a water?
They're getting one for me. Thank you.
Welcome.
Yes.
Would you like a water? Oh, I don't have water.
Thank you, sir.
Can I have one?
No, this is fine.
All right. Ready?
Yes.
Ready? Okay. Mr. France, you ready?
Yes, sir.
All righty. We're probably going till about 5. So,
That's perfect.
Amy, can we go to page 79 once you're up and running? '79. And actually, while we're getting that up, maybe we could address the point that Mr. Juan made, and we could present and move to endorse Mr. France as an expert, Your Honor,
in what areas?
in the field of forensic dam failure investigation.
Mr. Juan?
I don't object to his qualifications and being able to testify in the field. I would observe though, a couple things. For him to give any opinions that go beyond the four corners of this report, would be violated in close order, because they named him as an expert witness and never supplied us with a report. And so the anticipation is he's going to testify that it's in the report, number one. And number two.
Okay, let me just jot down. What's number 2, please?
Number two, Your Honor, would be for him to, that's a pretty broad definition, what he just said of the investigator or terminology.
Field of forensic dam failure investigation, I think is what you
Yes,
said.
Your Honor.
That's a pretty broad field. If that, they intend to have him vouch for other experts in specific fields in their testing, that's not within the four corners of the report, we could check that too.
Okay. Anything else?
That's.
Anybody else on that side of the V want to be heard?
I would join with fellow counsel here, but I have not heard, and I appreciate his experience, but I have not heard, question whether or not the hydrology and hydraulic aspects have been satisfied under this broad category.
Okay, thank you. Spence?
Your Honor, first, this is maybe the multiple times that the plaintiff's attorneys have brought this up, which is that the case management order did not require that a non-retained expert produce an expert report in this case. We did not retain Mr. France as an expert. That's why he did not produce an expert report for this case. So that was not a requirement in the case management order. And as to the other matters, Mr. France is here to talk about the work that he has done as a forensic dam failure investigator. Both he talked about Oroville, but obviously specifically to Edenville. And he can testify about what's in this report. I didn't hear the plaintiffs objecting to that.
I didn't either.
And so really, if the standard I think the plaintiffs have set in this case is that with Mr. Sturdivant, he did produce an expert report that was not written by him. It was written by attorneys, which we talked about. But the point is that Mr. Sturdivant.
To quote my friends from the Mid-Atlantic region, that dog don't hunt. I've already ruled on that multiple times. So, we're good on it. So.
Your Honor, I know, I'm not challenging that
I get it.
ruling. My point is just that the standard set by the court's ruling was that Mr. Sturdivant could testify about his conclusions in that report because he read and agreed with it. That was the standard. So here.
Counsel, you're overstating very broadly statements that I have made previously. My orders and that which I have declared on the record will speak for themselves. It's not the first time. It's just such a broad read of what I've done. And it's not especially helpful to what we need to do today. So let's just, let's focus on what's before us. The primary first response is case management order did not require an expert report by non-retained experts.
Yes.
Okay. Other than, what are your, and I agree that it sounds to me like the defendants are not objecting, the plaintiffs are not objecting to this witness testifying as an expert as relates to information within the context of the IFT, which is Exhibit 106, with the proviso of Mr. Dubin that I'm not sure he's qualified in the hydrology hydraulics. And if we get to a question where Mr. Dubin feels it necessary to interpose an objection to a specific line of questioning, he can certainly do so, as can Mr. Wan. But that's what I understand the objections and sort of the lay of the land. Let me ask plaintiffs what their response is to your principal response, which is the CMO did not require an expert report for non-retained experts. Mr. Wan, we have talked about this previously. Yes. Yeah. That's good. Request qualified experts, certainly appropriate.
Sir, are you being paid for your time? In other words, you say you're watching the trial, you say you've been, the testimony has already gone through the trial. Are you being paid to monitor the trial?
I've been paid for preparatory time. I'm not being paid for the time I'm sitting here today. I've been paid for preparatory and travel time.
Preparatory is you've talked and met with Mr. Gamble and prepared for your testimony today. And you've been paid for it, correct?
Yes.
You paid for your travel here.
Yes.
Your Honor, I would consider that to be a retained expert. He's being paid to prepare for testimony in a trial. That's a retained expert. So I think he had to go beyond the four corners of the report. Again, he's here to testify about the report. We have no objection to that, Your Honor.
Right.
But for him to go beyond the four corners of the report and testify about things that are not contained in the report, I think it's inappropriate.
Okay. Mr. Gamble, response.
Your Honor, I disagree that we have retained Mr. France as an expert. However, I don't think that that's actually relevant to the objection because what we're asking Mr. France to do is to testify about the contents of the report and the plaintiffs aren't opposed to that.
Right. Okay. Do you agree that there's been some compensation for the time that Mr. France has expended in getting ready for testifying in the case.
Yes.
Why do you think that doesn't make him retained?
Because it's,
And I know it sounds like there's no retainer agreement or what you would typically see with the, you know, but tell me what's the status?
we're simply paying Mr. France to compensate him for his time. I mean, he's here essentially voluntarily.
No,
And so we're not expecting him to foot the bill for traveling out here and
No,
spending time.
nobody's
That's it.
suggesting out of travel cost. I don't think anybody's saying travel cost. You're paying for the travel that makes you retained expert. I don't think anybody's saying that. I think what, as I hear Brother Counsel saying, is it's not the travel costs. It's not the expenses of being here. Of course, you're a subpoenaed witness. You know, you have to pay for that. But the time leading up to it, I mean, that to me is it's a closer call. I don't know what the result is, but so that, what's your position on that?
I mean, our position is still that we didn't retain him. I mean, even though we are compensating for his time, we don't see that as one and the same thing. I think really for the purposes of the court's ruling, plaintiffs and defendants all agree on the issue, which is that Mr. France can talk about the
Right.
report that he helped write
Okay,
and that for the team he led.
right. Thank you. There being no objections to the qualifications of this, of Mr. France, with the exception of the proviso of Mr. Dubin, which is noted. And I'm not ruling on that at this juncture. If you, as we're proceeding through this journey together, if you see a basis to object, please let me know, or Mr. Juan also to let me know. But as I understand it, there are generally not objections by plaintiffs to Mr. France, provide expert opinions that are a oral memorialization of that which is indicated or reflected in the IFT, which is Exhibit 106. Is that correct, Mr. Juan?
Yes, sir. I mean, if there's a question that goes outside those bounds, I will stand up.
Okay, and Mr. Dubin?
I fully support Mr. Watt.
All right. Okay, so the court will allow opinion testimony under 700 series of the Michigan Rules of Evidence. In addition to there not being an objection, just as I found the plaintiff's experts to be qualified to offer the opinions and to share the wisdom of their decades of experience with the court in their case in chief, I likewise find Mr. France to have the necessary training, education, experience, and specific information and understanding of the specific facts giving rise to the litigation in this case, which I believe will be of assistance to me as the fact finder in helping me reach the necessary conclusions that I am required to. He may provide opinions that are related to the IFT. If plaintiff's counsel believes that we're going beyond the port and starboard running lights of the IFT, then they will let the court know, and the court will do the best it can to rule on objections after I give the defense the opportunity to respond to any objections interposed. Is that satisfactory to the defense? Oh, geez. That's and the reason the record will reflect the court is laughing. The court is laughing at myself because I keep calling the people the wrong parties in this case, like I do at home. I can hardly keep my kids straight. At any rate, Mr. Juan, Mr. Dubin.
And yes, Your Honor, thank you.
All right, let's continue. Thank you, Mr. France, for your patience while the lawyers do the lawyer thing here in the courtroom.
Easy for me to sit here.
Now you get to participate a little more, so.
Amy,
ahead.
could you magnify that lower paragraph that's highlighted? Thank you.
What page again are we on?
Oh, I apologize. This
No,
is
you-
page 79.
Do apologize for. Thank you. Plans with us, page 79. Good.
Mr. France, the report indicates that available lake level records showed that Wixom Lake rarely rose significantly above its normal level even prior to FERC regulation. And so let's look at the next page and magnify the chart there. Thank you. Mr. France, could you explain this chart to us, please?
Can we hold on just a sec? Is this,
This is page 80. It's the next page.
thank you. And Mr. France, I've told this to a number of the witnesses who've had who have been with us for more than a couple hours. On occasion, I'm going to stand. It's not any disrespect to you or to the lawyers. It's just I have some L4, L5 issues. And I just would prefer not to have them manifest themselves in grimaces or whatever. So if I'm standing, I'm paying attention, but sometimes I need to move around. Go ahead, Mr. Gamble.
No disrespect taken. Thank you.
So could you explain this chart to us, please, Mr. France?
Yes, so this is a chart that we compiled from records that we could assemble of annual high lake levels at Wixom Lake from original construction through to the event that occurred in 2020. On the left is elevation, and on the right, or on the horizontal axis, so the vertical axis is elevation, horizontal axis is the years, calendar years. And at the top there, the minimum crest elevation and the design crest elevation are noted. And down at the bottom, elevation just below 676 is noted.
And how would this historical data have factored in to a risk analysis for the Edenville Dam?
Well, in a risk analysis, I think if we're looking at a risk of the reservoir exceeding that maximum or the minimum crest elevation, so exceeding the crest elevation of the embankment, records like this would suggest that the likelihood of that is lower because we've had 100 years of experience of the dam operating without, up until 2020, without a reservoir level that is getting very close at all to the crest of the dam.
So, someone might look backwards in time, see that the lake hadn't gone up that much, and concluded that it's a low risk possibility that the lake will actually go up high enough to threaten overtopping.
This would be a piece of information that would advise that decision, yes.
Amy, could you drop that magnification and let's go to section 5.2 of the report. Could you magnify that first part? It says that the rainfall event that occurred on May 17 through 19 was significant, but not extreme. And so, and could you magnify thank you. And so that second highlight, it's reasonable to ask why the storm resulted in a record high Wixom Lake level, 3 feet higher than the previous lake level that occurred in 1929. Is that something that the IFT examined, that question?
That was a question we identified that yes, we were interested in examining.
Amy, could you go to the next page? Could you, on the next page, could you highlight the table and the highlight, or magnify the table and the highlight beneath it? Thank you. So Mr. France, it says the data presented in table 5 shows that the Wixom level does not correlate directly with precipitation. Could you explain this data for us, please?
Yes, this is data we collected on a selected number of larger rainfall events that occurred over the history of the project. And the table shows on the left, under the heading maximum lake level, a date, and an elevation. That elevation would be the maximum level that the lake rose to on that particular date. And there's a depth above normal lake level. So normal lake level would be the lake level that's operating with no storm. And then to the right is rainfall and duration. So rainfall in the number of inches of rainfall and duration in the duration of that rainfall event. And the thing that we observed there that that the IFT looked further into is September 12th, 1986. There was a large flood that if I remember correctly, the term was known as the Great Flood or had similar sorts of terms. September 26, 1986, which was quite a significant rainfall, 6.83 inches in 3 days. And it was interesting when we compare that 6.83 inches in 3 days, the lake level actually only went up by about a half a foot above the normal lake level. Whereas on May 19th, 2020, we actually had less rain in that storm, 4.3 inches in 2 days. And the lake went up to 5.5 feet. And there are other inconsistencies in there. If you look at September 12th, 1986 and April 13th, 2014, the 1986 flood, 6.83 inches, reservoir only went up 0.5 feet. Less rainfall in April 13, 4.53 inches, goes up by 1.4 feet. So all we were really saying is when we can't just look at rainfall and say rainfall correlates. If you were to plot rainfall versus maximum lake level, it would not be a linear plot. They don't correlate. They're bouncing all over the place.
So even an ordinary or not unusual amount of rainfall could generate in circumstances a really high lake level. Is that it?
It seems that that's possible.
Yeah. And you mentioned that this is something that the IFT team worked on. Amy, could you go to page 88 and magnify that highlighted area? I'll give you a second to refresh your memory, but if you could explain to us what the conclusion was to explain how it was that a relatively ordinary amount of rainfall generated such a high lake level.
So what we concluded looking at this, and it's when one thinks about it, becomes sort of obvious, is that the ground conditions and the rainfall conditions preceding when a particular rainfall event happens influence the percentage of the rainfall that is converted into water running over the surface versus water that percolates in. So if the ground is relatively dry, there hasn't been much rain recently, the ground isn't frozen, there's going to be a greater percentage of water that falls on the ground that percolates in, that doesn't turn into water running across the ground and into the streams and into the lakes. Conversely, if there's been some significant rainfall before this storm happens, or ground is frozen, under those conditions, there's less of the rain that's falling that percolates into the ground, and a greater percentage of it can flow across the ground and flow into the streams and hence into the lakes. So those conditions, those antecedent moisture conditions and the ground freezing conditions can explain why you could have a smaller rainfall actually create more runoff. So rainfall and runoff don't correlate with each other. You need to consider the conditions. And in September, that storm I noted in September is relatively later in the year. Conditions were dry, it's warm, there's no frozen ground. So more of that water ran in. In this May event, we believe that what happened is we had some rain in the week or so before, week or two before this event. And in addition, we may have had some latent conditions of ground being frozen so that more of that water converted to runoff and flowed into the streams in the lake.
Amy, could you go to 83? And magnify the chart that comes up? Or the figure, rather. Thank you. Mr. France, do you recall that there are two different rivers flowing into Wixom Lake, the Tobacco from the west and then the Tittabawassee from the north?
Yes.
Amy, could you go to the next page down? And magnify this figure. Oh, other one, the top one, the green one. Thank you. Mr. France, does this figure depict the amount of precipitation that fell in the area? Is that what's being shown here?
This was the data that we had on the precipitation during the storm that occurred in May 2020.
And is it that the dark blue is more water falling and the light green is less water falling? Am I understanding that correctly?
That's correct.
And which river was receiving most of the rainfall according to this figure?
The highest precipitation numbers were in the Tittabawassee River Basin rather than the Tobacco.
So most of the water flowing into Wixom Lake during this event came from the Tittabawassee side rather than the Tobacco side. Is that your understanding?
The IFT believes so, yes.
Amy, let's go to page 82. Mr. France, I think you mentioned before that the IFT developed a hydrologic and hydraulic model to simulate the May 2020 rainfall and flood event. Do you remember saying that?
Yes.
Let's walk through the process of that model development as it's described in the report. Yeah, could you highlight those two, Amy? These highlighted sections refer to model calibration. What is your understanding of what it means to calibrate a model?
In this particular case, we're working with a real event. We have an event that happened. We have information from lake levels that were reported by Boise Hydro. For their lakes, I think we had information from some of the other lakes that were not owned by Boise Hydro, but we had data on the different lake levels that were occurring. Of course, the most important one to us is Wixom Lake, because that's the lake behind Edenville Dam, which failed. But what we're trying to do, what the team was trying to do with the calibration is to look at its model and to try to calibrate it so it was producing as closely as we could the actual reservoir water surface elevations that occurred.
And it says that the model was calibrated against the measured and estimated lake levels. And then it says that documented spillway operations and gate openings of the event were used in the model to simulate spillway outflows. Do you have an understanding of what that means?
I just want to interject, we're beyond the scope of, I don't know what we do with the science particular, they should be, he's not saying I'll make sure what that means.
Response.
I think he's just explaining what his understanding is of the language in the published IFT report.
Do you have any objection, Mr. Wan, conducting a brief voir dire on this issue?
I do, actually. I think it's disruptive.
Respectfully overruled, Mr. Wan, briefly. You may examine.
I'm okay right here.
You okay with that, Mr. Gamble?
Yes.
Yes.
Sir, when you say we, you're talking about the IMT, correct?
The IFT as a whole, yes.
Yes. And the hydrologist and hydraulic persons on the panel were Dr. Miller and Mr. Lassassi, correct?
Dr. Miller was a member of the IFT and Dr. Lasasso was an engineer assisting Dr. Miller with the work, yes.
He was identified as a support person in the area. Correct.
Correct.
And those two are the ones who are the experts in hydraulic, correct?
That's correct.
They're the ones that work with the model, put the inputs in the model, decide how to calibrate the model, correct?
Correct.
And then they come back and report to you that here's what we're doing, folks, in the IFT. Here's how we're doing it, correct?
Correct.
And so you're relying on what they say to decide whether this is calibrated appropriately, correct? You're relying on they say they calibrated appropriately, you're relying, correct?
We, in some cases, ask questions about what they were reporting back to us, but in the end, we are relying on them for the calibration, yes.
Just so we're clear, the model itself is not attacked.
The model itself is not, that's correct.
So and different values they place into the model to come up with their conclusions. We don't have that information in the IFT report.
In detail, no, you do not.
That's all.
Look, any questions in response to Mr. Wan's question or Mr. Dubin, any questions?
Mr. France, you mentioned that the engineers who would work on the model would report to you what they were doing. Is that right?
Yes.
So, Your Honor,
Go ahead. Hold on.
Your Honor, that's all I'm asking him to tell us. I asked him what his understanding is of what happened during this process. That's what I'm asking him. I'm not asking him to come to an expert conclusion about whether the model was calibrated properly or something like that. I'm asking him what are the parameters that went into developing the model according to what the people who put it together reported to the IFT team.
And that, Your Honor, I'm sorry,
Go ahead.
that, Your Honor, is hearsay. If it's not written in the report, which is an exhibit in this case, it is hearsay. And for him to comment on what they told him was their process in coming up with this model that we don't have is hearsay. And it's, well, anyways,
I
that's
understand.
my judgment.
What's your position that which you seek is hearsay?
I think it's entirely appropriate for the leader of the IFT team to tell us about the conversations and conclusions that the IFT team reached. I think that experts in this case have submitted similar testimony for the past 8 or 9 days, and we're not asking for anything out of the ordinary.
What is the question? Say your question again.
I'm honestly, I'll ask the question that I think that I had asked, which
That's
is,
fine.
uh,
Ask whatever question you want to ask. And then go ahead.
Mr. France, in your understanding, the sentence documented spillway operations and gate openings of the May 2020 event were used in the model to simulate spillway outflows. What is your understanding of what that means?
Okay, the objection, Mr. Wan, is respectfully overruled. The witness may respond to that. I do not think that this is asking, we've already established that this witness is the lead. It's been established, the witness is the lead for this report, this team, that which the question currently before the witness is permissible. Objections overruled. Go ahead.
Could you repeat the question?
Yes.
I'm old, my memory.
That's okay. In your understanding, Mr. France, what did it mean for the model to use documented spillway operations and gate openings of the May 2020 event to simulate spillway outflows?
What that meant to me is that Art and Hayden, mostly Hayden, who's implementing the thing, used whatever information they had on how the spillways were operated how the gates were open at various times and used that as part of their model simulation.
So in your research and for this, preparing for this report, did you conclude or did you find that the gates at the Edenville Dam were actually opened at different heights at different times between May 17th and May 19th?
Yes.
Amy, let's go down to page 387. So deep dive. Sorry, a lot of pages to turn.
387.
387. Amy, could you magnify the highlighted top two? Mr. France, it mentions on page 387 of the report that the models were created using both HEC HMS and HEC RAS software programs to simulate the storm event and lake levels. In your experience, Mr. France, was that unusual for them to use those models for this purpose?
Preface comment with I am not a hydrologist or a hydraulic engineer, so I do not know the details of HEC HMS and HEC RAS, HEC RAS. I do know from I've been serving on the ASDSO program committee for over 20 years now and review abstracts every year for putting together the program and helping put together that program. And I know within that program, I see year after year presentations and papers on both of these programs, HEC HMS, HEC RAS. I know ASDSO does courses that they present regularly on HEC HMS and HEC RAS. So I know that both programs are used within the dam safety industry. I know they are for two different purposes. HEC RAS focuses on rivers. HEC HMS focuses more on reservoirs and reservoir levels. Don't know the details of them. I know they both are used within the industry. Within this model, I don't know exactly how Art and Hayden use them for the different parts of the model, but I do know that both programs are used in the industry for dam safety purposes.
And for that second highlighted sentence, it says that that sub-basin outflow hydrographs were input to simulate the time series of the reservoir gate operations and to simulate reservoir inflows, outflows, and water levels. What was your understanding of what it meant for the IFT to simulate, or for the model to simulate the time series of the reservoir gate operations and to simulate the reservoir inflow, outflow, and water levels?
Once again, I don't know the details of how Hayden and Art use this, but from our discussions within the IFT and those various working sessions that we had, my understanding is what we were doing is we had information on the reservoir levels in the different lakes behind the dams. We had information on how the gates were used at the different dams. And what we were trying to do was create a model that put the water on the ground, transferred some portion of that water over into surface flow and into the rivers. And what we were trying to do in the model to calibrate it was to match water levels at the various dams as well as at Wixom Lake. The most important one being matching the reservoir at Wixom Lake, but we were trying to match all the various lakes in the system to the data we had on what those lake levels were during the course of this flood.
Amy, let's go to that line that goes on 2 pages. Oh, good. Can you magnify that sentence that goes on 2 pages for us? Thank you. Mr. France, it says that modeling the gates using the radial gate function allows the RAS model to simulate the spillway function as either weir flow or gate flows based on the reservoir elevation and gate openings through the simulations. Do you have an understanding of what the difference between weir flows and gate flows is?
I do.
Could you explain to us, please?
Yeah, the gates that we're talking about at Edenville and the other dams in the Boyce Hydro system are radial gates. So they're gates that are that are mounted on pivots, curved metal surfaces. And basically, when you lift them, as you lift them, there's a concrete sill that the gate can originally sit on. So if the concrete sill's sitting on or if the gate's sitting on the concrete sill, there's no flow going through the gate. As you lift that gate, water will start to flow through the space between the gate and the concrete sill. And as you lift it higher, more water flows through. During that period of time, when the water behind the gate is actually higher than the bottom of the gate, what's occurring is a thing we call orifice flow, where the water is flowing in that vertical gap between the bottom of the gate and the concrete sill. And the water is flowing through that gap. And hydraulically, that's a different flow than if it were just flowing over the concrete sill itself. Once the gate lifts far enough, if the gate lifts far enough up above the whole water surface, then the water is flowing free over the concrete surface of the crest and the concrete sill. And that's free weir flow. And as these gates are raised during the course of the flood, you can have at various times the orifice flow, and then you can have weir flow when the gate is lifted free enough that the water is just flowing over the weir with no constraint by the gate.
Is it your understanding, based on this language in the report, that the IFT's model could account for the different flow between orifice or weir flow?
No objection, Your Honor. First of all, it's leading, second, leaks without foundation.
Rephrase the question, please.
Mr. France, based on your reading of this report, is it your understanding that the IFT's model could account for both weir flow and orifice flow?
Okay, the objection on leading is overruled. What's your response on foundation?
I'm simply asking him, as the leader of the IFT and someone who helped write this report, what his understanding of these words are.
Thank you. The objection is respectfully overruled. You may answer the question.
From the discussion we had in our team meetings, it was my understanding that the model that Art and Hayden used was capable of modeling both the weir flow and the gate flow, depending on gate open.
That second series of highlighted language says the spillway gate openings. Could you please read that sentence just in your mind, and once you're done, just tell us what your understanding of that sentence is.
My understanding of that sentence is that from the data we had on how the gates were operated, the various openings during the time frame from May 17th through May 19th, that those were input in the model to actually simulate those gates being open to those amounts at the various times.
Yeah, I object and I move to strike. It's without foundation. Everything that he's saying, just based on what these other people, the hydrologists, tell him. He says, this is my understanding of what's going on. It's based on what the hydrologists tell him. It's hearsay. He doesn't have a foundation independently of what they tell him. Okay, and that's my opinion.
Response.
Your Honor, I think the court's already ruled on that objection last time it was raised, which is Mr. France is perfectly appropriate for him to come as the leader of the IFT team and explain to us what the IFT report says and what his understanding of the words are. We're not asking him to get into these other people's heads. We're asking about his understanding.
The objection as to this question is overruled. I think there is an adequate basis based on the prefatory testimony that took place starting at 1:15 this afternoon and continued for about 30 minutes before it was offered as a possible expert, is satisfactory in conjunction with the format of this particular question. I don't think this witness is able to testify, here's all the specific things that, Bill Smith did or Fred Jones. But as far as the overall work of the task force together in the process of preparing the report, which has been admitted into evidence, which was relied upon at great length by Mr. Sturdivant, commented upon by Mr. Sturdivant. Mr. Sturdivant is the first witness who ever spoke about this exhibit in the September hearings that the court conducted in the Dalbert proceedings previously. So this has been a report that has been relied on by both sides in the preparation for this litigation. The witness can answer questions that he is aware of, and a question of what does it mean when you say, quote, the spillway gate openings for May 17th through 19th storm event were input into the HEC-RAS model at the time series based on the spillway gate operations provided by Boyce Hydro through handwritten logs and interviews. This witness has already testified. It was every member of the task force agreed with this report, which the negative pregnant of that statement is he did as well. So this is not a hearsay statement or a request for an explanation of the hearsay statement. It is rather, may I have the explanation of why you, as well as 5 others, but you made these conclusions. The objection is respectfully overruled. You may inquire.
He actually has already answered that question, so we can go to the next.
Oh, yeah, sorry. The request to strike is respectfully denied.
You could magnify. Yes, that the middle part. Thank you. So this is in section F1-5.2 titled Hydrologic and Hydraulic Model Calibration. Mr. France, we've emphasized some language in the report here. Why don't I give you a second to read this and just let me know when you're done.
Okay.
Mr. France, what is your understanding based on this language of how the model was calibrated?
Again, it goes back to answer a few moments ago is basically we have the 2 basins, and within the basins, we have these dams that are upstream of the Edenville Dam. And we're starting upstream, and we get a model to predict what's going on at the most upstream dam, which in this case, Secord. And once that calibrates pretty well, then we route the outflow from Secord plus whatever additional flows may come in between Secord and Smallwood. We route those down to Smallwood, and then from Smallwood, it routes down to Tittabawassee. So it's walking through the whole basin, from upstream to downstream, and trying to, from all the data we have, calibrate at every point. That we're not just matching down at Edenville, but we're matching all of those lakes coming all the way down.
And so it's your understanding that the model was calibrated using data from gate openings upstream of the dam on the Tittabawassee side. Is that right?
As well as the gate openings at Edenville, but they calibrated using all of the gate openings that we had.
Amy, let's go to page 89. Mr. France, was it your understanding that the model de- was able to depict the size of the spillways on the Edenville Dam?
Yes.
And was it your understanding that the model was able to account for contraction of the water flowing through the Edenville Dam's spillway gates?
We did have discussions of that during some of our working sessions, and that is a phenomenon that we know happens. The spillway, each spillway gate is a fixed width, and on either side of the spillway gate, or it's either side of the spillway bay, there's a concrete structure. There's either a pier or there's an abutment wall. And as the water flows in between those concrete structures, we know the water does actually contract a little bit. So if you have a 15-foot wide bay, the water, you're not going to get free flow through, or orifice flow for that matter, through the full 15-foot width. This contraction squeezes the water down a little bit as it comes through that bay. And in the discussions, we talked about that, and Art and Hayden indicated that that was accounted for in their model.
Here on page 89, could you highlight that top one, Amy, please? This is section 5.2.5 titled Hypothetical Alternative Scenarios. Mr. France, it says that with this calibrated model, the IFT considered several hypothetical alternative scenarios related to hydrologic and hydraulic aspects of operations. What does that mean?
So after we as a team got a model completed and calibrated that was, in our view, accurately predicting what actually occurred during the flood in 2020. As a group, we talked about, well, some people are going to ask some questions about, well, what if things were different, counterfactuals? What might have happened if things were different? And we discussed a number of counterfactuals that we thought might be important, that people might ask questions about, might be interested in. And then we used the team, and Art and Hayden again, running the actual analysis, used the model that had been calibrated to the factual performance, use that model to look at those counterfactuals and say, what does the model say the reservoir level would have been if that counterfactual was true?
Amy, could you go to the next highlight that's blue and magnify that for us, please? So as you considered these counterfactuals, this highlighted language refers to establishing a baseline actual case. Could you help us understand what the role of the baseline actual case was as you ran these hypotheticals?
Sorry, I'm trying to figure which case this is referring to. Might need to see the larger text around this.
Yeah, maybe if you could do away with the magnification there. Yeah, go ahead and take your time, Mr. France.
Okay, can you blow that up again, Amy, please? So I believe this, the sentence really is just clarifying that the baseline case, the one that was calibrated to the estimated reservoir elevation at the time of failure, 6183, and the Edenville gates being opened 7 feet, and that the lake was at approximately normal water level before the May 2020 flood, and the powerhouse was not operated. So all we're really saying here is that was our baseline case that was used in the calibration.
And what, okay, so that's what actually happened. And by 6183, did you mean 681.3?
I'm sorry, 681.3.
That's fine. Great. And so let's look at one of the counterfactuals. Amy, could you go to the next page and magnify the blue highlight? Or at least the first two there. Thank you. So when the IFT talks about pre-lowering scenarios, could you help us understand what that means?
We're looking at scenarios where, for whatever reason, it was decided to lower the lake in advance of this storm, whether it was lowering the lake back in April, earlier in May and March or whatever, basically to lower the lake level down before this storm happened.
And with scenario number 3 under pre-lowering, it says pre-lowering Wixom Lake to the run of the river operations over the concrete spillway crest, estimated to be 670 feet. The spillway crests were actually a little bit lower than 670 feet. Isn't that right?
It is, I believe it's a little bit more than 2 feet lower than that.
So why is it that the IFT assumed lowering to the spillway crest would actually only lower the water to about 670 feet rather than the height of the spillway crest?
The, with Edenville Dam as it was operating at that point in time, the hydropower license having been revoked, water could not be released through the powerhouse. So the only way that any water that comes into Wixom Lake could pass through and downstream of Edenville Dam was through the spillways. So even if you lifted all of those spillway gates up as far as you could, even if you removed them, you just physically took them out of the spillway bays. So there are no gates in the spillway at all. It is a concrete crest. The water could not possibly be at the concrete spillway sill. Just can't be there unless the Tittabawassee River isn't flowing and the Tobacco River isn't flowing. Otherwise, water is flowing into that lake. That water's got to go somewhere. And the only place it can go is out those spillways. So you can't be down at the spillway crest. It's physically impossible. So it has to be somewhat above that. So we talked about this during some of our meetings again, and Hayden and Art reported back, well, we've got to estimate a number there. And they looked at, there were 2 instances, and I don't remember the dates, but there were 2 instances when Wixom Lake had actually been lowered over the winter. And there were lower period times. They looked at those, and they looked at the record of the water in the water levels in Wixom Lake when the lake had been lowered. And their conclusion from looking at that was that a reasonable number was a bit more than 2 foot of flow over the spillways to elevation 670 was a reasonable number to handle the water that was flowing coming in the 2 rivers, in the Tittabawassee and in the Tobacco.
Amy, could you go to page 355?
Excuse me.
Uh, Mr. France, you mentioned that the Wixom Lake actually had been lowered over the winters, and so the IFT looked at that data. Is the chart here, the figure here, does that reflect what you were just talking about?
That is one of those lowerings. It's winter 2018, 2019. So that is winter after, I believe the license was revoked in, if I recall correctly, September 2018. So it was a good case to look at, and one can see that they're late into April, we're down at 670 or so feet. There actually are times when it's a little higher than that. Earlier in the winter, when the river flows were a little lower, it was maybe a little lower than that. But even in the dead of winter, there's a stretch of time when it's about 670. So again, there was their best judgment of what would be a good number for the gates being fully opened and operating in May.
Amy, could you go back up to page 89? And actually to page 91. Could you magnify the blue highlight, please? The counterfactual that we've been described, or that you've been describing and we've been talking about, it says that the pre-lowering with the gate openings limited to 7 feet would have resulted in less than 0.2 feet difference in peak lake level, which the IFT believes is unlikely to have prevented the failures. Could you explain what this sentence means, please?
So it means that the model that we've just been talking about, that calibrated model with the conditions of the gate open and the lake pre-lowered would have resulted in only a 0.2 foot difference in the peak lake level. And the last phrase of it is that, excuse me, we talked about this a lot as an IFT and really felt that the degree of accuracy of our understanding of the static liquefaction failure and the limitations on our understanding of what the true cross-section was, what the true soil properties were at the location where the failure happened, because all that material was washed away. So best data we had were hundreds of feet away. We didn't know exactly what that was. There was enough uncertainty about the mechanics of that static liquefaction failure that we felt that a 2 tenths of a foot difference, we just did not feel that was enough that it would have prevented the failure.
Amy, could you go to page 402 or 401, excuse me? Okay, this is a tough one because the words are so small. Could you magnify just the highlighted the best you can, Amy? Just that highlighted line 7. Thank you. Could you do just magnifying across? Thank you. Yeah, that's what I meant. Ooh, that doesn't help, does it?
I think I could read it.
Okay, I'll give you a second.
Okay.
So according to this table, the level of Wixom Lake, had the gates been opened to run of river level, the model concluded that the level only would have dropped down to 681.1 feet. Am I reading that correctly?
Actually, what this says is that if the lake had been lowered to run-of-the-river level, which we estimated as elevation 670, the gates at Wixom Lake had been opened 7 feet, which is all they could have been opened in May of 2020, because the gates were sitting there. They hadn't been revised. 7 feet was as far as they could open them. If that were true and the powerhouse was not operated, then the reservoir lake level would be 681.1.
And it failed at 681.3, right?
Correct.
And so that's your testimony previously about only, it's less than 0.2 feet of a difference, right?
It's an estimated 0.2 feet of a difference, correct?
Amy, could we go to page 151?
Hold on just a sec, please. I want to
Okay.
just write some stuff. What was the height of failure? 681.3.
Yes.
I thought you said 1.5.
Page 151 is where we're going next.
Yeah, I would just ask for a delay while I wrote some stuff down. So. Me too.
Okay.
What page?
Page 151. Before you magnify anything, you can see that this is in section 7.2.2.4, which is titled Effects of FERC Actions. Amy, can you magnify the highlighted areas there? Thank you. It says that the following is the IFT's analysis of FERC's options to exert pressure on the dam owners to at least partially upgrade the spillway capacity while still maintaining a license. And then one of those options that the IFT analyzed is the second bullet point, which says order lowering of Wixom Lake to the spillway crest. Mr. France, could you actually just read the orange highlight, starting with if the spillway crest?
Certainly. Order lowering of Wixom Lake to the spillway crest hyphen. If the spillway gates had been kept open, the lake level would have been lowered to about 6 to 8 feet below the normal lake level. This option by itself would have had a limited benefit with respect to reducing the chance of overtopping the dam. If this option by itself had been exercised, the peak lake level would have been about 0.2 foot lower than the level at the time of the May 2020 failure.
And that conclusion in the last sentence, that's the result of the modeling work and the counterfactual studied by the IFT, right?
Correct. It's basically the same thing we were just talking about.
And then could you read the blue for us, please?
Certainly. This option would have also impacted the ability to generate power and therefore would have reduced the funds available to the dam owner to upgrade spillway capacity.
And can I actually pause you right there, Mr. France? What's the problem with cutting off the revenue to the dam owner?
Again, as I talked about earlier in the day, the revenue from the power generation is the dam owner's only revenue. And if you're trying to force the dam owner to do something to spend money to build a new spillway or to modify his existing spillway to increase capacity, you've reduced his financial resources to potentially do that.
Okay, could you read the second blue sentence, please?
This option would also have impacted recreational use of the lake as well as property values, and possibly have caused adverse environmental impacts.
And then in purple, it says that considering these factors, this would not have been a good option to exercise. Was that the IFT's conclusion, Mr. France?
Yes.
So even after the fact, studying this with the benefit of hindsight, the IFT still concluded that ordering Wixom Lake to the spillway crest would not have been a good option to exercise. Is that correct?
Yes, with the one caveat that this, we are now talking about here, the time frame when the license was still in place, because that relates to this revenue question.
And to that topic, with the license in place, this was under FERC jurisdiction. Is that what you were meaning to say?
That's correct.
And so, could you, well, according to that last highlighted green sentence, is it correct that the IFT was told that FERC evaluated this option and judged it not to be a good option to order the dam owner to undertake? Is that your understanding?
From our interviews with FERC personnel, that was our understanding, yes.
Amy, let's go all the way up to page 11. Mr. France, you've mentioned once or twice the gate operations at the Edenville Dam. Amy, could you magnify that? Thank you. Let me give you a second with this sentence and just let me know when you're done. Or with this paragraph, I mean.
What page, please?
11.
Thank you.
Okay.
What did the IFT learn about the original gate hoist system at the Edenville Dam?
Our understanding from the information we had is that hoist system was constructed in such a way that the mechanism that lifted the gates would actually run into interference with the beams that were running across the top of the spillway as they tried to lift the gates. So such that it couldn't lift the gates any more than about 7 feet.
And so from the beginning, it's the IFT's understanding that the gates could always only go about 7 feet high. Is that right?
That was our understanding, that was the original system. And it was that way from when the dam was built back in the 1920s all the way up until 2012.
And then what happened in 2012?
In 2012, we saw some correspondence between FERC and Boise Hydro. And it appears that they at that point recognized that. I don't know if it got recognized in an inspection or how it got recognized, but they recognized that. And Boise Hydro, as an alternative, said, well, we could fabricate this A-frame system to supplement the hoist system that was originally constructed with the dam. And we could put this A-frame over top. We can connect it to the lift points on the gate. And with that, we can then lift the gates an additional 3 feet to get them up to 10 feet. And then they actually went out and constructed that A-frame, and they went out and they physically tested it. And they showed that physically, with that A-frame, they could connect to the gates and they could lift those gates up and get them 10 foot open.
And at some point, did Boise Hydro stop using those A-frames?
That was our understanding, is that an inspection was done in 2019. And the inspectors who looked at that had two concerns. One was for safety of the operators trying to operate this A-frame sitting on top of these gates, and you're pulling it up. There's a lot of force on those, either whether it's chains or cables that you're using. Those could snap and could hurt people. During the case of a flood, you'd be out there, water's flowing over the spillway. It'd be even more dangerous. And in addition to that, they also noticed that the lift points on the gate appeared to bend or otherwise be deformed by the gate, by the A-frame lifting them. Just the way it connected into those connecting points, it was putting stresses on it, was lifting them. So they were worried about the fact that if you tried to use the A-frame, you might actually just snap off those connecting points to the gates. And once you snapped off the connecting points to the gates, you can't do anything. You can't lift them at all. So that for those two reasons, they were concerned. And the recommendation coming out of that inspection was you really shouldn't use these. And then when we talked to the operators, and we talked to all the operators who were at the dam during the 2020 event, they said that because of that recommendation, they were reluctant to use the A-frames and to try to lift the gates further, and if they were used sparingly, if at all, during the 2020 event.
And were there plans in place to address this problem?
That was our understanding, is there were plans in place to put in a new gate hoist system. They actually had modified, there were similar issues with the other three dams, with Sanford and Secord, and third one right now, but there were similar concerns with those, and they had actually gone in and replaced the hoist on all of those. And our understanding, the reason they hadn't done that at Edenville was because they were talking with FERC about all these big plans for a big spillway, and they didn't want to go spend money on the hoist when they're going to build a big spillway. But in 2020, they decided they're going to go ahead and do that. They'd ordered the equipment to do it, and the plan was to do it later in the summer of 2020. And very, very unfortunately, this flood occurred in May 2020 before that was done.
Amy, let's go to page 44. And this is one that spans 2 pages. Is it possible to, let's see if it's helpful or not. It might still be too small.
That's not too bad.
Okay. So I'll give you a second to review this information and just let me know when you're done.
Okay.
Mr. France, what is, and help me if I'm mispronouncing this, but what is a SCADA tool for measuring gate operations? Do you understand what I'm asking?
I do.
Okay.
SCADA.
SCADA,
and
okay.
Believe SCADA stands for Supervisory Control and Data Acquisition. And the SCADA tools are used by hydropower operators. They're also used by water dam operators, and they are electronic and computer systems for monitoring various things that you could monitor on a dam: water levels in the reservoir, water levels at the tailwater. You can even connect in your piezometers for piezometric levels within the embankment if you want. Anything that would have a electronic instrument can be connected to the SCADA, and that could include, you could connect an electronic instrument to a gate so that the SCADA system could automatically monitor the opening of that gate, how far open or closed it was.
Did the Edenville Dam have a SCADA system connected to its gates?
It did not.
So what were the sources of information available to the IFT in order to determine what the gate operations were during the flood event?
The first source of information we had
Sorry,
available,
it's SCADA, SCA.
SCADA, all capitals, SCADA.
Thank you. Go ahead.
Uh, uh, He just said more terms for you. So what were the sources? So if there was no SCADA connected to the gates, what were the sources of information available to the IFT for determining the gate operations during the flood event?
But the first thing that we found is from the information that was provided to us by Boyce Hydro. We found that there were handwritten logs from all of the dams with the operators entering in these handwritten logs the various operations of gates, when they operated a gate and what the operation was, opening at so many feet, closing at so many feet, whatever. That was the first information we had. We talked about that as a group and we were, well, it's not we're a little concerned about how much, how accurate that is. Operators are out there working, there's a flood going on, are they getting it right or whatever? And there could be some uncertainty with that. So the other thing we decided to do is we talked to the operators. We interviewed each of the operators, there were 3 or 4 of them. And we interviewed them, Teams meetings with them, interviewed them separately. And we separately asked each one of them for their recollections of how far the gates were opened on each one of the Boyce Hydro dams.
And so based on your conversations with the dam operators, were you able to reach a conclusion about whether the handwritten logs were reliable?
As we looked at the data from the handwritten logs and we looked at what the gate operators provided us, we debated back and forth of which is the most reliable, the logs or the operators. And we concluded that the operators' reports were probably the most reliable thing we had because as we said, we interviewed all of them separately. And independently, they all gave us exactly the same gate openings for all of these gates on all 4 dams, which actually was quite remarkable that you talked to these 4 different people separately and they had the same openings. We compared them to the handwritten logs and they were not terribly different for Edenville and for Edenville, they were not different at all. They all reported exactly the same thing as the handwritten logs. For Smallwood and Secord, there were some small differences. And for Sanford, there was a more substantial difference. The operator saying that they were open 10 feet, the handwritten log saying 7 feet. Of course, for the failure of Edenville Dam, Secord's not important.
You mean Sanford?
Downstream. Sanford. Sorry, Sanford is not important. It's downstream. So it is not as important. The others are. And we, in the end of the day, decided we think the operator's information is the most important and that's what we chose to use, or the most reliable, and that's what we chose to use.
In your experience, is it unusual for a dam to not have a SCADA system connected to the gates?
For small hydropower facilities with owners like Boyce Hydro, I don't think it's unusual. The SCADA systems are certainly used commonly by the larger hydropower operators in this part of the world, Consumer Energy up until the point where they sold their hydro units recently. Probably have SCADA units on a lot of theirs. The big operators, Southern California Edison, Pacific Gas and Electric, they probably do. They have resources to do it. But for these small hydro units owned by small companies or small individuals built a long time ago, I don't know that it's that unusual.
Let's change topics. And Amy, could you go to page 9? 9. And this is in the summary. This is geotechnical factors. And then Amy, could you magnify the highlighted language? Thank you. I'll give you a second with that, Mr. France. Just let me know when you're done.
Yes, thank you.
Could you help us understand what you mean or what the IFT means with this sentence about the primary geotechnical factor contributing to the failure was the very loose to loose sands present in the embankment as a result of the initial dam construction?
Okay. What you mean by that is, we concluded, that the failure mechanism for the Edenville Dam was a static liquefaction failure of that east embankment, left embankment. And an absolute requirement for that is loose, very loose to loose sands. The phenomenon does not occur for medium dense sands, for dense sands. You need loose to very loose sands. So that was the factor that drove the failure. Had the original specifications that we found said they were supposed to place in layers and compact them. Had they done that, I think they almost certainly would have ended up with a medium dense sand at least, and that material would not have been susceptible to static liquefaction, and this failure would not have happened. So you needed those loose sands. That was a requirement for the failure mechanism.
And the Federal Energy Regulatory Commission revoked the license in September 2018. Is that right?
To my recollection, yes.
And then the dam failed in May 2020. So about how much time was this dam under Eagle's jurisdiction before its failure?
Do that math, and I think it comes out of somewhere around 20 months,
Yeah, so less than 2 years.
less than 2 years.
In the IFT's work, did it ever conclude that Eagle was aware of the fact that the embankment had not been constructed consistent with the original construction plans?
I am not aware of anything we saw that indicated that.
And is that information someone could gather simply by looking at the embankment of the dam?
No.
Amy, let's go to page 153. This is in section 7.2.2.5 titled Effects of Eagle Actions. And Mr. France, I'll give you a moment with this. Just let me know when you're ready.
Okay.
In that first orange highlighted sentence that starts with given, the IFT says that it's noteworthy that a regulator in most dam safety programs would not typically raise questions about embankment stability unless there is specific physical observation suggesting problems. Could you help us understand what the IFT meant in this orange highlighted section?
I'll try. What we were getting at actually is a little bit of what I talked about earlier with the lack of comprehensive reviews being a part of dam safety practice. And in most state programs that I know of, they really have revolved around physical inspections, visual physical inspections, some review of past analysis that have been done, but really focus a lot on those physical inspections. And that unless there were, for a dam that's been operating generally satisfactorily for 100 years, without physical observations of problems suggesting instability like slumping, cracking, or newer increased seepage, unless there were other data available that would suggest a problem, the state regulator would not normally raise that as an issue. And it's interesting to note in this case with Edenville, they had constructed some stability berms and seepage features in other parts of the embankment, but they actually had been done because they had seen either seepage on the face of the embankment or they'd seen slumping on the face of the embankment. That's why those were done. And FERC had Boyce go do them. That wasn't true over in the east side. So for typical practice of a state dam safety program, I think with absent that visual evidence, it would not necessarily get flagged.
And with the blue highlighted sentences there, it says that for the Edenville Dam, and I think you mentioned this, the dam had already gone through a potential failure mode analysis, several geotechnical investigations, and 6 FERC Part 12D inspections and evaluations, the most recent being in 2015. And Mr. Friss, did the IFT review all of those documents as part of its work?
Yes.
And then it states that the conclusions by the engineering consultants in FERC were that there were no significant embankment stability concerns, which had not already been addressed by embankment overlays and drain modifications. Could you explain in any more detail what the IFT meant in this blue sentence?
The words are fairly clear, I think, we're basically saying that that through the FERC program, there had been multiple Part 12D inspections. And as I explained earlier, those 12D inspectors have to be approved by FERC. The owners have to submit qualifications to FERC. FERC reviews those qualifications. They then either approve or disapprove of them. Once they're approved, they can go ahead and do the inspections. So all that was done. The FERC engineers reviewed whatever reports were prepared by those FERC Part 12D consultants. So even more back to the question of what a state regulator might do when this dam now comes into their regulation is, in addition to not seeing any evidence of instability problems on the section of this dam that ultimately collapsed, in addition, they had all of this history of what should have been qualified professionals who had looked at it, and part of their charge was to look at stability. There's a section in the FERC Part 12D reports called stability, and the consultant is supposed to look at that. They're supposed to opine on it. All of these qualified consultants had opined that there was not a problem for any areas other than the ones that already had the overlays. To a state regulator, that would be sort of increasing evidence of stability doesn't really need to be on my radar.
Amy, could we go to, well, let me ask, was it a common practice prior to the failure in the dam industry for these engineers doing these types of reports to focus their stability analysis just on certain cross sections of an embankment?
Certainly was not uncommon.
And was it, was it not uncommon for them to focus just on areas that they thought demonstrated some visually perceptible problem, like there was slumping or leakage or something like that?
Again, I would say that was not uncommon.
And is part of the work that the IFT did to try and educate the dam safety industry about lessons to be learned in the future about how to do their jobs better? Is that correct?
That was our belief that was part of our charge, yes.
And so you had testified earlier today about the concept of hindsight bias. And did the IFT make a distinction between, well, here's the information that was available at the time and the common practices at the time, versus here's our recommendation about how to improve those practices? Did the IFT draw a distinction between those two things?
We tried to.
Amy, could we go to page 162? And actually, so this is in the lessons to be learned section of the report, and we've highlighted geotechnical evaluations of the Edenville Dam. And I'll give you a second with this if you need it, Mr. France, to refresh your memory.
Thank you. Okay.
So, Mr. France, it says that the IFT did not find evidence that a comprehensive geotechnical review of the Edenville Dam embankments was ever completed. Was it the IFT's recommendation that that's something that should be done in the future in the dam industry?
Yes, it is.
Nevertheless, this paragraph goes on to explain that the fact of the matter is that prior to the failure, the stability analysis that had been done were not a comprehensive geotechnical review. Is that right?
That's correct.
And at the time of the failure, there was no engineering report that identified any additional embankment stability issues that hadn't already been resolved, right?
To my knowledge, that's correct, yes.
Amy, let's go to the next page, 163. Let me give you a second with this sentence, Mr. France.
Okay.
Could you explain to us what the IFT meant about challenging the validity of two common practices in the embankment dam stability analyses?
Well, certainly a practice that I had commonly seen was the first one, which is that we're going to look at an embankment dam, we're going to analyze the maximum section and assume that it's the critical section. There's nothing any worse than that anywhere along the embankment. And we'll do our stability analysis there. If we have satisfactory results there, we're good. And this case certainly challenges that because it shows that, well, we had those maximum height sections, but they had been modified with filters and no one in the series of FERC inspections or at any later time recognized that, well, golly, those are done and they're taken care of, but the next tallest section is the slope steeper. And maybe we ought to look at that. And in addition, it wasn't quite recognized that with the variability materials along the length of this dam, maybe with that variability, there's a section that's worse. So all we're really saying is that was to some degree a common practice. And we need to rethink about that. We need to think about what are there potentially other criticalities rather than just maximum height. And the second one is often, again, with dam safety and many locales and many practices being driven by physical inspection without evidence of seepage or slumping or something else to indicate that we have potential problem, maybe we don't need to look at it. And here, certainly it shows that we didn't have those issues on the left embankment of Edenville Dam, and indeed there was a problem. However, the problem, even with a low calculated factor of safety for static stability under the left embankment, it wasn't so low that it was going to fail from static stability. The problem was the unknown condition of the loose sands or unrecognized condition of the loose sands and potential for static liquefaction.
Amy, can we jump up to page 13? Could you highlight just the orange? Or magnify just the orange? Thank you. Mr. Francis testified earlier today that your work on the Oroville Dam IFT investigation.
What page again? Sorry.
That's okay. 13.
Thanks.
Led to a change in FERC regulations. And does that last sentence refresh your memory about when those regulations went into effect?
Yes, it does.
So it wasn't until April 2022, right, that FERC updated its regulations to include the type of comprehensive reviews that you had recommended. Is that right?
Correct.
Okay. Amy, let's go to, actually, just 1 second. Yeah, let's go to page 10. And we're going to look at the highlight just on the very bottom that goes into 2 pages. So if we can, yeah, perfect. We can magnify that. Thank you. And I'll give you a moment with this highlighted language, Mr. France.
Page 10.
Yes, pages 10 and 11.
Okay.
Mr. France, at the very end of this highlighted section, it talks about how, well, actually, I apologize. Let's just start at the top. It mentions that as early as 1978, it was recognized that the spillways at the Edenville Dam cannot pass the probable maximum flood. Mr. France, at any point, did you discover that FERC had required Boyce Hydro to lower the level of Wixom Lake because of this problem that they were aware of since at least 1978?
We did not see any indication of that, no.
And then it goes on to say that the conclusion about the lack of spillway capacity was repeatedly confirmed between 1991 and 2003. And then it says that based on interviews, it appears those involved with the project thought that the spillway capacity was about 50% PMF, and the likelihood of a lake level exceeding the embankment crest was perceived to be very low. Could you elaborate on what the IFT meant in these sentences?
Yeah, first I clarify that it was between 1991 and 2013, not 2003.
Oh, thank you.
And yeah, I mean, basically what we're just observing is this is a long period of time, 1991 to 2013, that conclusion was confirmed even with PMFs changing a little bit here and there. So a very long time this went on. And the only explanation we could put forward for that, or we could interpret out of that, is even though it didn't meet the prescriptive standards guideline of 100% probable maximum flood, FERC's belief in this was that the capacity was close to 50% probable maximum flood. That's not a very likely flood. So we continue working with the owner to try to get to probable maximum flood capacity, but the flood risk of overtopping this dam is still low, and it's low enough that we have time, we can keep working on it.
So as far as you could tell from your investigation into what happened here, the FERC staff who are working on this, they just didn't perceive the risk posed by this lack of spillway capacity as being all that high.
Swan. It is leading. It's leading. I'm not sure what else it is, but I know it's leading. So, no, I'm not saying you're not right, but I know it's leading, so I know I'm not going to allow the question. And it leads us
Happy to
to,
rephrase.
hold on. The question is, how much longer with this witness?
With me for my direct, probably less than 40 minutes.
All right, then we're probably going to recess now so
Yep,
that I can
okay.
have the opportunity to talk to lawyers. The objection is sustained. You can think all night about how you want to rephrase your question. Mr. France, thank you for being with us. Any objection to Mr. France being allowed to step down for the evening and to join us again tomorrow morning?
No, Your Honor.
All right, Mr. France, thank you. Be careful. It sounds like virtually every witness we have in this case is from Colorado. So here in the Great Lakes State and the Great Lakes Basin, we're enjoying quite a bit of God's bounty of snow. And so while you won't confuse us with Aspen or Breckenridge, be careful out there. So we'll see you first thing in the morning.
It was
Thank you.
33 degrees in Denver today.
I have a group of fraternity brothers that ski in Colorado every year. And they started the ski trip this year on January 12th, but I was doing some other things that day. So I missed that week.
You missed nothing.
Okay.
No good skiing in Colorado.
Okay. They did go fly fishing though and caught a lot of fish. So that would have been good. Okay. What else do we need to address before we recess for the day? For it's your case right now. So for the defense, anything else?
No.
Oh, yes.
Nothing, Your Honor. Nothing, Your Honor.
All right. As always, continue to be very appreciative of the excellent lawyering taking place and the excellent lawyers in front of me. Look forward to everybody being back safely with us in the morning. Thank you. Court's in recess until tomorrow morning.
Do you want to meet with us, Judge?
No, if you want to meet with me, I'm happy to meet with you, but sorry.
I thought you said you wanted